No, copy shot.
May I have your lordship leave to file an urgent appeal of Group 2 appeal regarding the upper.
Application coming immediate urgent.
On 18th order has been passed.
Huh?
On 18th order was passed.
Have you applied for certificate?
Yes, my lord. I applied with server copy. It's extremely urgent, but upper primary panel will expire on 25th. Let it be on day after tomorrow, my lord.
Huh?
Panel will expire on 25th. Let it be day after tomorrow, my lord.
Yes, give the 48 hours
My lord,
notice
my
with
lord,
copies
my
to all the others.
Deeply obliged.
My lord, same prayer I am praying, leave to file an appeal, my lord.
18th.
Without that
Order passed on?
No. My lord, what happened, my lord, in this matter? My
Order passed on,
order passed on, my lord, 16th. My lord, kindly grant leave, my lord. Otherwise, my lord, I will be seriously thinking.
Have you applied for certificate?
Yes. I have annexed this one. Deeply.
Lord, may I have Malas kindly leave to file and move applications. This is in connection with Bodhu sex matter. Lord, we have filed these applications. We are willing to file these applications. Lord, raising the maintainability issue. Lord, let us.
We have already said in our order that.
No, Lord, there is no applications to that effect from our side. That's why we are filing these applications. We are raising the maintainability issue.
No. Where is your affidavit on merits?
That is affirmed. That is affirmed. We will be filing on tomorrow. Lord, let this matter also appear on tomorrow. Otherwise, the department will not accept it. But these applications, let it.
Applications filed by whom?
Applications filed by the FRRO, respondent number 1 to 4 in the writ petitions. FRRO and other government machineries will not file these applications raising the maintainability issue.
But you have already raised that issue in your affidavit.
There is no separate application. That's
no, in the affidavit.
In the affidavit, we raised the issue, but this is a separate independent applications.
No,
that's
not independent, Mr. Tiwari. If you are agreed by our prima facie observation on maintainability, you challenge our.
This is the problem we are facing. That's why your lordship will kindly decide this issue, whether it is maintainable or not.
We have already said.
That point has been kept open. This is a.
We have said, Mr. Tiwari.
Let it appear tomorrow. Let it appear.
No, wait.
Yes.
We have said that on the basis of what you have submitted, we have dealt with your. We have said that we will not prioritize and take up the point of maintainability without seeing into the records for merit of the.
Yes, we have already affirmed an affidavit. We will be filing the affidavit on tomorrow itself. But at the same time, we are filing this.
Tomorrow, yesterday was the time.
Already sub. It was sub. These applications also sub. I have already sub these applications. Let it appear tomorrow along with them. Let it appear tomorrow. Will make submissions to that effect.
No. If we allow you, again there will be.
No. This is what as of now, we have been raising this maintainability issue, but it is kept pending. Your lordship has not decided that. That's why we are filing these applications, raising the maintainability issue, asking, requesting your lordship to decide our application first. We have already affirmed an affidavit as per your lordship's directions.
After saying that we will decide maintainability and merit, can we segregate that?
Let it be listed. There on tomorrow. We will make some submissions. On merit also. Let it be listed tomorrow. Let it be kept to the record. Let it be listed.
Let us see what is your prayer. Come to the prayer.
Yes, prayer is decide the issue of maintainability of the present habeas corpus petition at the threshold before going into the merit of the present habeas corpus petition number 7.
Right. So we have returned a finding on your prayer. We have said that we cannot seclude it and take it up independently only on the ground of maintainability.
Let it appear. Let it appear. If necessary, we will be making submissions on merit. Let it appear tomorrow.
It is
your lordship will kindly consider one thing.
No, Mr. Tiwari, please explain to us that when we have passed an order.
No, that point.
Using your prayer.
No. So far as that prayer is concerned, from the very beginning, we are harping on this point that the writ petition is not maintainable. But there is no independent applications on our part. So, in order to prevent the abandoned concern, we are filing these applications so that your lordship can decide it. So, but my lord, logically concept, maintainability.
Infructuous application, Mr. Tiwari.
No,
because
it
we
is
have
not.
decided here.
No, it has not been decided. It has not been decided.
Go through our order. Don't
Yes,
say
I have
not-
seen, my lord, on the last occasion, your lordship, my lord, so far as maintainability point and all these things are concerned, my lord, your lordship has not decided the same as yet.
Yes, we
Uh,
have
your lord-
said
Your lordship has said that this report should be filed or everybody should be filed.
going into any
So,
adversarial submissions.
absolutely, my
We
lord.
have expressed our mind to the
Let it appear, my lord. Let us come tomorrow. Let it appear. We'll, if necessary, my lord, we'll place it on record, my lord, all the relevant facts. Every bit already affirmed and served. And also, we also serve this copy of the applications to the, my lord, all the respondents, all the opposite parties.
Who are the applicants here?
Here, the applicants, my lord, your lordship would find.
Mr. Trivedi was appearing with the.
For the Delhi police.
You are for the.
I am for the applicants, my lord. Here, the applicants is Interim India, Home Ministry. Second is, my lord, Government of India, government.
এইটা ওই যেদিনকে হেভিয়াস কর্পাসটা আছে
Tomorrow it is.
কালকে আছে
হ্যাঁ।
Tomorrow
Tomorrow is it. But develop, let's do it.
My lord,
Mr. Tiwari, where is your affidavit on merits? Do you
Yes.
have a copy?
I'll
Can
hand
you
it to
give a copy?
Yes. In course of, no, it will be supplied.
Just give 2 Xerox copies of your affidavit. We are saying, if you don't want to give, don't.
No, we'll give.
Then you will again take a point.
No, my lord. Absolutely not, my lord. Outside the, I am saying, my lord.
Thank you.
my lord,
Well, only one thing, sir. Only one thing.
my lord, I am seeking leave to file appeals, my lord, by a server copy without certified copy. My lord, urgency is, my lord, it is relating to recruitment of upper primary selection process. The panel will going to expire on 25th of September. My lord, order passed by the honorable single bench on, my lord, 10th of 12th of September 2025 and my lord 10th of September 2020. My lord, upper primary selection process panel will expire 25th September. I have no alternative way. I am waiting for my lord certified copy. I have applied. Great.
Yes, sir.
But may I mention item number 4 of today's list?
Why you have mentioned?
Can it be after vacation?
You are for the appellate.
And for the my learned friend is
I am
here.
for the candidate.
Matter for selection process of post of library clerk. We have alleged that the committee was biased towards me. That is why I was not selected.
You were terminated.
No.
Selection process.
It is a fresh selection process wherein, my lord, I stood first. Panel has been approved by the college authority and the DPI also approved. I have joined and working.
Then what is the application about?
But can one is a stay application. Lordship was of the opinion that it can be hard at the application stage. All the pleadings are, all the materials are there.
1 week after vacation.
Well, I have a problem between the 28th to the 5th of November. But I have a family engagement. That's why I'm
Take 2 weeks after vacation.
as it should be.
My lord, may I be permitted to mention a matter? My lord, I was appointed a special officer in respect of an order passed in an appeal under section 19 of the Contempt of Courts Act. My lord, in that I was directed to look after a particular premises and inspect so that no clinical establishment is run from the particular premises. My lord, this matter, I was supposed to file a report. This order was passed on 8th of August 2024. My lord, there was no returnable date, which is why I cannot file the report. In the meantime, I was directed to carry out fortnightly inspections. My lord, it is not in the list, my lord, because my lord, I am the special officer. My lord, presently what has transpired is, my lord, one of the it was a hospital which was running at the ground floor. There is an entrance, a pharmacy.
When the matter is not in the list, when it will appear, you remind us.
Because my lord, there is no returnable date. There is no, my lord. This was my lord. It was heard by Justice Joymallo Bagchi and Gaurav Kant. My lord, that honorable bench had taken up the matter. There is no returnable date. My lord, for 1 year it has not been. There is no returnable. My lord, the issue being, my lord, today one of the premises entrances has broken down because it has not been in use. It was a glass wall. It has broken down. There may be issue of security. Since I am the special officer, I am carrying out regular inspection. I thought I had to bring it to the.
Take your report without the matter being in the list, sir.
My lord, because my lord, no, none of the parties are now taking steps.
Let them not. You do your work when it appears. You tell us. We will accept your.
Because my lord, there is a direction every fortnightly. I am taking steps.
Very good. What problem you will face?
Very well, my lord. I shall continue. My lord.
I know.
To ensure that there is no clinical establishment being run in terms of an undertaking given by the appellants who were the contemners, that they will, without seeking permission and necessary fire licenses and other purport, they cannot.
You are not responsible for the maintenance of the.
No, my lord, I am not. The only issue being, my lord, today one of the glass doors are broken. If tomorrow, my lord, this is not brought to the court's notice, since I am an officer of the court and by an court's order this has been passed. If this is not brought to the notice, I have brought to the notice to the parties. I've held meeting. I've informed the parties. Even the parties are not inclined to take any steps. But tomorrow, nothing should transpire where the special officer was appointed in respect of the building and one of the glass doors have broken and it has been not been brought to the notice of the court. There has also been notices affixed with regard to property tax non-payment. That is part of my report. I have not been.
How are you concerned whether property tax has been
Well,
paid?
It is affixed to the gate. I have taken note of it. I have informed that
Let the parties take
Very
steps. That's not within your domain of appointment.
my lord. Very well. Only because this was the concern, my lord, I had to bring it to my lord's notice.
Best, Mr. Das, put them on notice that you've mentioned the matter. Let them.
Much obliged. I shall do that, my lord. Much obliged.
The notice that I mentioned. Take steps to. This mentioning is not upon notice, is it?
Not with notice. If my lord so permits, my lord, tomorrow I shall give them notice and come and mention once and bring it to my lord's notice. That is all that I need. That
Then at least you will
my lord.
discharging
My lord.
notices to both the parties and
I shall do
tell
that.
you will mention day after tomorrow.
Day after tomorrow. My much obliged.
Yes, sir. Why to be mentioned?
But I'm for the respondent. If you also kindly look into your lordship last order, your lordship sought for an affidavit from the so that matter can be resolved.
What have we done?
But this relates to the A category scale of pay. No matter from what date we will get, from the date of examination or date of publication of result. This relates to 1719 lordship the session. Number the honorable single judge pleased to direct to give us from the date of the last date of examination. In the meantime, lordship, they have preferred this appeal.
During such time, Assistant Secretary of the Government of West Bengal, in consultation with the NCT, came into a conclusion that no, the A category scale of pay will be given from the date of publication of the result for the session 17 and 19 only. And that's why you will also directed them to take instruction whether they are agreeable with the decision of the Assistant Secretary or not.
So that the appeal can
Be
be.
disposed of.
Yes, what is your?
We have already accepted the order passed by the additional secretary to the government of West Bengal, and to that effect, an affidavit has been prepared. And your lordships, on earlier occasions,
Then your,
directed-
nothing remains in your appeal.
Nothing
no,
remains.
no. There is nothing remain. We have already accepted.
Then have you given the benefit
No,
to them?
no.
No, since the appeal is pending, this is order of stay.
Lordship,
When the appeal will be disposed of, I will get.
Lordship, kindly see
Then
the
what
affidavit.
is your instruction, sir?
Lordship, my instructions.
That can we record since you have accepted the.
Yes. Your lordships
No
can.
longer want to proceed with the appeal.
Yes.
Huh?
Yes, lordship.
Are you taking on instruction?
Yes, I have already taken instruction.
Show us that instruction, sir.
Yes.
There's a direction for filing affidavit to that effect.
Lordship, verbally instructed to file an affidavit.
Yes. Whether they will accept the decision of the Assistant Secretary or not.
Where is Mr. Kamal Mishra? He's not there.
No. Lordships, he will be.
You are Mr. Pratap Shan?
Yes.
I had a talk with Kamal Mishra. His daughter's examination is today. That's why he will be late or may not come today.
So they are wanting to give it from 22nd May 2019,
Instead of March
17th March.
20. Yes.
Now the single judge said give it from
17 March.
So you don't have on your, then if it is given on 22nd May, you will again go and file a contempt before the single judge.
No, my lord. I'm accepting because either of the way I'll be entitled from the June, the 1st of July. Whether it is May or March, I will entitle from the 1st of July.
Why May or March?
Because the increment will start from the 1st of July.
22nd May.
Yes, my lord. Or 17th March. Is 2 months difference. 2nd May.
So there is no question of withdrawal of the appeal ordered by the said decision.
Appeal may be disposed of.
The judge has been modified.
And we have kindly restricted it to the 17-19 session because it relates to 17-19 session only.
Where has been stated 17 to 19 sessions, sir? Where is the assistant?
But it's already on record. Last question I have handed over.
In that session is mentioned?
Yes.
Then it's okay. Where is that, Mr. Ghosh?
But it's last question I have handed over.
8th April 25.
8th April 25. The Assistant Secretary order is third page.
Third?
Third page. First, second, third. Result order.
10th of January 24.
10th of January. Yes, 10th of January.
Connection with another
Another petition. for the same issue.
To show us, Mr. Ghosh, where is the order?
The impugned order. My lord, your lordship is taking up
175.
the FMA number, my lord.
They are taking up FMA combined paper.
Yes, my lord. Then, my lord, kindly come to
76. 76.
page 76, my lord. You can come. 76.
No.
Page
76
of the paper book.
were taken up for analogous here,
No, no. All are hard.
but we have taken up for
The
analogous.
appeal was taken up analogously.
All these are arising from separate orders.
Separate orders.
Was taken up analogously.
47.
Date of the orders in all the other matters are also same.
Same. And
And same order was passed in all.
yes, Maldas
Manthas or
Justice Mantha Soda.
same date.
Same date. 5th July.
So where is it that the session is when you are saying from 16 March 2019
16 March 2019, the last date of examination.
of which session?
1719.
Where will we
But the resident order of the Assistant Secretary, paragraph 5.
ये ऑनलाइन
Well, may I hand stop? Fine.
you have to copy.
Yes, I have 2 copies, but
একটা আমারটা বের করুন।
can I take my copy?
17.
Paragraph 5, my lord. Well, can I take up my copy?
Records repeat.
Well, item 4 কি হলো? Item 4?
Sengupto, it was mentioned today morning
Oh.
by the appellant saying that you keep it after vacation. The other side, state, I think, was there.
Well, yes, I am for the university, my lord.
We usually do not adjourn, but when they made that prayer, we kept it 2 weeks after vacation. They ought to have informed the world. Oh, yes, Mr. Dotto.
My lord, there is, my lord,
Or not.
my lord, another development. My lord, I'll tell you, lordship, my lord Justice Tandon had, my lord, passed an order.
Then we keep it after vacation.
Very well.
After vacation. I was not, we were not getting an explanation effect that what happens to the pre-97 parcels.
My lord,
Wherein the rider was prior permission of the DI.
my
There is only one judgment, Akhtar Hossain Chaudhuri to that effect.
note karo.
Akhtar Hossain Chaudhuri, 2013, Volume 1, CHN 309, I think. Justice.
My lord, I'm most
Grateful.
grateful. I'm most grateful.
Please find out whether that order was referred to the
Larger bench.
Ah,
Larger.
Mr. Banerjee, we have kept it on the after vacation. There had been one problem. We were asking a clarification from Mr. Dot. Please check out.
I will definitely, my lord, assist your lordship.
Because so far as we have seen in the order of Utpal Kanti, Mr. Banerjee also check up. Utpal Kanti were deciding Tarok and what is that?
My lord.
One or something.
Yes, yes.
Tarok was relating to post commission appointees.
My lord.
7 Act and 2005 Confederation. These cases are pertaining to pre-commission, wherein the rider is, some matters, wherein the rider is subject to permission of the DI, higher qualification. There is only one judgment in your favor to that effect, that is Akhtar Hossain Chaudhuri, appointed by Justice Chattopadhyay and his lordship then was.
No, so far as my case is concerned, my lord, I have a separate notification in this point.
Because the
Yes.
I think he's referring to 1993 notification.
No, not 1990, 2006 notification, for 2005 notification. Well, I'm just briefing. তুমি এখান থেকে বার করো না, সাহেবদের জন্য তো 2 কপি রাখা হয়েছে। But the notification says if on the date of my appointment, I have already, my lord, started my courses, but it did not end. It did not end. Then, my lord, I am entitled to higher pay scale without permission. Yes.
Yes, because you have, yes, that is.
No, not this one.
There's judgment.
This one. Keep 2 copies. Is a teacher prior to
Still you give us.
আরেকটা কপি দাও। 1595, my lord. 159. And the next page, my lord. I'm just realizing, well, this is another copy.
We are aware of this because this was dealt with in a coordinated judgment in which Justice Talukdar sitting with Justice Bhattacharya.
Yes.
That judgment was relied upon by Justice Aniruddha Rai in passing orders in some of the cases. Those are also before us. Those are also. Our question is we are not getting an answer from the Utpal Kanti Koron that what happens to those persons who did not who were enrolled, but their result came subsequent. but their result came here in this case where you enrolled.
Yes. I was enrolled. I was already enrolled, and my lord, I have also finished my course. My results were waiting.
Mr. Dotto, you get
My lord,
a copy of that, you can
I'm going to
apply
copy
that.
that.
I come and
My
apply
lord, the
that.
other thing, my lord, I need to, my lord, point out, my lord, there is a coordinate revision bench judgment, my lord, decided over by my lord Justice Tandon. My lord, that judgment, my lord, Mukul Singh, my lord, in that,
does not
my lord, regarding physical education.
that is Amitav Manna.
My lord, Amitav Manna, my lord, in P97. My lord, Amitav Manna was, my lord, not after 1997 was promulgated. 1997. And my lord, that Justice Tandon's order, my lord, is now, there is an SLP fight. That is also pending. My lord, I need to, my lord, tell you, my lord, this is recently happened.
SLP, but my lord, no stay.
No stay.
No stay.
Absolutely not.
No
I'm
stay.
not saying that. But this is the position. I'm just wanted to point it out to your lordships.
Very good. Then you point it out to us on the
next day. On the next day. Just to my lord, because this is the development as on date, I should point out.
Keep it on 24th November. Sorry, 28th October.
28th October.
28th October.
My lord,
Then
can
you
it be
go
any
on
day?
24th.
Very well, man.
28.
Want any other date?
No. 28.
Let it see.
28th October.
Now.
Another matter, where is that matter, Mr.
My lord, Mr. Abhishek Prasad was appearing. My lord, I had a discussion with him on the last day. Lordships desired, my lord. But his case is, my lord, he is a honors graduate and in a different subject, my lord, not physical education particularly. Because, my lord, I find that regarding physical education, my lord, the authorities also, my lord, have dealt with it in a different manner.
Physical education, what has been said by Justice Tandon?
My lord, that it will be getting the benefit under Utpal Kanti Court. And my lord, that benefit, the higher pay should be granted. My lord, that is under challenge. My lord, I'll
No, this is the judgment. For physical education. Well, this is the date to copy.
দিয়ে আমাকে একটা কপি দাও দেখেন এটা Google thing টাই
In this Utpal Kanti Gordon was considered.
yes absolutely
yes.
Quoted. And my lord, this is the SLP status.
SLP, my lord, is
No,
pending.
I am not saying there is any stay. I'm saying issue will be covered perhaps.
No, otherwise.
দেবেন আমার আগে তো আচ্ছা তোমার
Utpal Kanti Court, paragraph 272, my lord, the pronouncement, my lord, the ratio of the judgment, my lord, that has
Physical education. This is
physical education.
Physical education.
Physical education in
physical
particular.
education. You obtained it prior to entering into service.
Yes, no, I obtained, my lord, prior to entering of service, my lord, I have completed my physical education. My results were waiting.
My lord, the
On the date of my recommendation, I have.
My lord, the parameter.
Yes, I am covered.
My lord, the parameter is that, my lord, factually, my lord, the parameter is that, my lord, as on the date of, my lord, the last day of examination, my lord, that was the deeming provision. Instead of the result, one can proceed on the basis of that. Now, my lord, in his case, my lord, I have found, my lord, I have not seen, my lord, I have seen that, my lord, the June is the, my lord, 25th June, my lord, she joined in service. And my lord, she appeared in the examination. The date is not specified. Only
No.
But we do not know, my lord, that is a factual.
No, it's.
Enrollment was prior to the appointment.
Yes. As in, my lord, the selection was there.
So when enrollment was prior to appointment and he completed it during his appointment, then no prior permission is required. So then his case is covered.
My case is covered.
My lord, but so far as, my lord, that distinction regarding pre and post 97, as your lordship has pointed out, my lord, that needs to be looked into. And my lord, as far, my lord, my humble understanding, my lord, the
My
question
learned
is,
friend.
my lord, whether, my lord, the lordship had this question, my lord, whether the physical education teacher.
So then you check up unless you assist us.
My lord, we will try our.
Mr. Prasad's matter.
Mr. Prasad's matter should be tagged. দেখো 4 না 6টা। So I think our item 6.
Item 6. Goni Khan.
My lord, I do not know the name, my lord. I just have to. Mr. Prasad said that he'll be here, but somehow I'll just.
Which is that matter, Mr.
My lord, I was appointed on 11th May 2005.
You also make a list of dates and come to us.
Yes.
But we will do that. Otherwise, my lord, it is not. Yes, absolutely.
It is very confusing.
My lord, we will
because there-
prepare this. Yes, my lord, we can file a short notes also if your lordship so desires. Tag
Can we keep it on 4th November? And Mr. Prasad's matter, have you seen?
My lord, there is no tagging here. My lord, I'll inform Mr. Prasad.
But that matter is here.
Lordship was of desirous that that matter should be there, and my lord, this matter would be tagged together with that matter.
Do you have the number?
Of that matter, my lord, I'm trying to, my lord, get hold of
So
it.
you get hold of
I'll inform your lordship in some time. Yes.
Yes. We are keeping it on 4th November.
4th November, as your lordship. Great. Yeah, my lord, I'm led by Mr. Sengupta.
I have not recorded it.
Very well. Yeah, record it.
Six more, I am for the appellant.
But I am for the UGC in item number 6. But first of all, in item number 7, COT copy I have not received. My lord, I have received not the hard copy, but the soft copy has come to me over by.
Let us hear what is the matter.
On 15th of September 2025, your lordship was আপনি জানেন আপনার মক্কেলকে মেল করা আছে আচ্ছা এবার আপনার মক্কেল দেয়নি whether UGC or AICT is the appropriate authority to ascertain the veracity of the qualification of the writ petitioner.
What stage you are wanting? Please show us, tell us on the.
Yes, sir.
It is on the question.
On the last occasion, my lord's pleasure was to direct my learned esteemed friend, my lord, to take instruction from the UGC whether an inquiry should be conducted in terms of the UGC regulation or not. That is the, my lord, extent of the query, if I have correctly understood the minds of the court.
Whether UGC or AICT, who is the authority? That was the.
As far as the UGC, the AICT is has the authority to conduct the inquiry because this subject, this advertisement was given by the AICT, and the said institute is centrally funded technical institution recognized by AICT.
Can we record your submission?
Yes, my lord, you can record. But it is given it, but I cannot submit it because the cost title here it is wrong. They have wrongly typed the cost title. UGC. I hand over করে দিন my lord কে
একটা কপি
একটা কপি আরেকটা কপি আমার কাছে আছে আপনাকে আমি দিয়ে দেবো
দিয়ে দিতে আসে
সফট কপি দিয়ে দেবো
ওনাকে জজ সাহেবকে দিন দুজন জজ এটা ইটস অ্যান ইনসাল্ট দিন
আমি
না
আপনি এটাকে স্ট্যাপে করে আমাকে
certain things cannot be compromised
আমি এখান থেকে দেখে নিচ্ছি
দিন না জজ সাহেবকে
সাহেবকে দিয়ে দিন আমি এখান থেকে দেখে
No, Mr. Bose was arguing whether you should be
No.
stating or not. That is an issue independent of the second part. When there is a finding that he was not a termination, should be.
reinstated with full back wages, that is the law.
That was his submission.
And second part, sorry, my lord, I'm sorry, I tender apology. The second part was, my lord, I cannot avoid the disciplinary inquiry if it is required. That is the mandate of the Supreme Court. But there has to be an inquiry before coming to conclusion. GB Pant Institute.
Zero. Order starts from paragraph 44. Therefore, based on the discussions and reasons set forth in the foregoing paragraphs, I am of the considered view that the termination order dated 24th of January 2024, whereby the petitioner's service were terminated, is unsustainable in law and liable to be set aside. Accordingly, the said termination order is hereby quashed. The first. Second thing, the petitioner's service shall be deemed confirmed from the date of expiry of the initial probation period. This is the second. Now, third is the petitioner shall be reinstated to his previous position with all consequential benefits, including back wages and continuity of service within 4 weeks from the date of receipt of this offer. This is one. Next, the Secretary, Ministry of Education is directed to appoint a person of impeccable integrity and impartiality to conduct an inquiry into the overall functioning of the institution. The appointed individual shall remain uninfluenced by any presumption that the action of high-ranking officials, including the director, assistant registrar, or any person responsible for making major decisions concerning the operation of the institution are inheritable proper. The objective, kindly have a look, this objective of the inquiry shall be to determine whether under the leadership of the present director, the institution is being managed in a transparent, efficient, and accountable manner. Now, this director, the present director, he joined in the month of June 2024. Now, the termination is relates back January 2020, December 2024. So, in the entire scenario, this present director was not present. So, there cannot be any assessment whether in his hand it's functioning transparently or not. And this was not the scope of the writ petition. In the writ petition, they challenged the termination order. Either the termination is to be set aside, or the writ petition is to be dismissed, or other order can be passed. But direction against the institution to find out whether it is in the safe hand of the present director is beyond the scope of the writ petition. This is my argument. Now, next, my lord, kindly have a look. Page 47, paragraph 47, sorry, paragraph 46. The chairman of the University Grant Commission shall appoint an expert of unquestionable integrity and impartiality who shall remain uninfluenced by the extraneous consideration in the discharging of his duty. The appointed expert shall conduct a preliminary inquiry to determine whether the petitioner met the eligibility criteria for appointment to the post of associate professor, specifically concerning the petitioner's claimed research experience. Because our claim was he was lacking this experience. 8 years experience, so 8 years experience was required. He had 4 years, we admitted. Rest 4, so we disputed. Now, this inquiry ought to have been done. That's the direction. Now, Mr. Bosch Malad made a prayer before the single bench after disposal of the writ petition. Now, this should be not by the UGC, but by the AICT. I oppose the same. Why I oppose, my lord? Kindly allow me to indicate 2 things. My lord, kindly have a look to page. Kindly come to page.
No, according to you, who will contact?
I shall show it to you, Your Lordship. Page 232 of my stay application. This is the AICT guideline regulation based on which
Second volume. 200
232.
question regarding his credentials, then why are you asking him to experience this?
Now, if your lordship turns to page 232, 232, 231, my lord, 5.1 minimum qualification for direct recruitment. Now, kindly come to page 232, clause J. Qualification for faculties in science and humanities. The qualifications for recruitment and promotion for faculty in the discipline of basic sciences, social sciences, and humanities shall be as per UGC notification dated so and so. In our institutions, my lord, there are two kinds of faculty member. One is technical faculty. They are purely guided by this AICT regulation. And those who are non-faculty, like the physics. The petitioner is academic physics. Now, my lord, that comes under this clause J, and that is to be guided by, my lord, UGC guideline.
For science and math, humanity.
Yes. Now,
faculty would be UGC.
UGC.
Pertaining to that, the authority will be
UGC.
And in respect of others, it will be AICT.
AICT. This is the regulation of AICT. AICT regulation says it.
Place it again. Qualification for recruitment.
Qualification for recruitment and promotion for faculty in the disciplines of basic sciences, social science, and humanities shall be as per UGC notification number so and so dated 18th of July 2018 and UGC guideline issued from time to time. Now, may I hand over the UGC guideline? On the right hand top, there is pagination. It starts from page 57. First page is 57. Or kindly come to page 60. Your lordship will get the associate professor eligibility. Second paragraph from the bottom. II. A good academic record with PhD degree in the concerned allied relevant disciplines, a master's degree. Now, third is a minimum of 8 years of experience. There at top, there is pagination.
60.
Yes, 60. II is the associate professor. He is an associate professor for the post of physics. Now, eligibility first regarding the PhD. Next is master degree. The third, a minimum of 8 years experience of teaching and or research in academic research position equivalent to that of assistant professor in a university, college, or so and so. With a minimum of service. So these are the required qualification regarding experience. Now, if my lord turns to,
But where is your advertisement?
on I shall, the same thing. This 8 years, that's there. Now, the one thing, kindly come to page 94. Top, there is pagination mark.
Yes.
Now, 10.0. Counting of past service for direct recruitment and promotion under CAS. Previous regular service, whether national or international, as assistant professor, associate professor, or equivalent in a university, college, national laboratory, or other scientific professional organization such as, because CIS said there is no scope of any teaching. This is only for research. Should count from the direct recruitment and promotion under the CAS of the teacher as assistant professor, associate professor, or any other nomenclature provided that. So there are 1, 2, 3, 4 conditions are there. Now, our specific case that these conditions, but these are similar to the AICTE guidelines also. This is lacking, he is not fulfilling these criteria. That appears from the report and a response sent by the Utah University or the USA University, from where he claimed the experiences.
So according to you, he doesn't have 8 years experience.
Yes, he has only 4 years experience. But 8 years experience.
That's on what basis you are taking into account?
Well, in the institutions which are recognized and other things are there. He fulfilled this criteria in respect of 4 years. So we proceeded on
Inspection office of UGC, according to you.
According to me. If your lordship think AICTE, I have no problem. But according to me, the law says that it should be UGC. I have no personal grievance. It may be UGC, it may be AICTE, but since law says UGC, I am indicating it before lordship. Your lordship can direct any authority. Let them ascertain and file a report. If he fulfills this, my lord, we shall not stand. He will get back everything. He will get back everything. There is no question of proceeding against him. Because already we dropped the proceeding which we wanted to initiate for his, my lord, conduct and other things. We didn't proceed on that. We didn't proceed on that.
But kindly note his words. He said drop.
Yes, we didn't proceed. What does it mean?
Yes.
We issued show cause. He replied. We said we are going to initiate a disciplinary proceeding. We did not. For this misconduct. It come to us, that's insufficiency or ineligibility. We proceeded on that basis only. So today we are not, my lord, harping on those points.
So then what prevents you from re-entry?
He is ineligible. The ineligibility criteria are
Expected in the year 2022.
2019.
2019. So after 3 years of 2024 was the termination.
Yes. Yes. But we proceeded for initially 2 years probationary period.
Mr. Jahan, termination order was set aside on the ground that it was not a termination simpliciter. 311 applicable, you can initiate a regular.
No, my submission.
Your submission is if at the very essence he doesn't have the qualification, why should you read?
The 311 is not applicable here. I have few judgment to show before lordship. Yes, it says, my lord, if the appointment is without any qualification or insufficient qualification, it's void ab initio. And for void ab initio, my lord, no proceeding is required.
You should have decided within the period of probation which was initially.
For initial probation period, my lord, he was, my lord, we were dissatisfied regarding his conduct. We extended it. We extended it. Now, when we were proceeding for all these things, my lord, it come to us. Because when we wrote a letter to the higher authority USA,
employer will engage a person and he will conduct an inquiry as per his sweet will, and after say 5 years of service, he will come with a ground that your initial engagement itself was wrong.
My lord, had there been any procedural latches, the matter would have been otherwise.
It's not a procedural.
Now he
Then
claimed,
you got to have ascertained.
yes.
At the time of entry, it was your obligation to check it. Your selection committee approved.
My lord, he submitted application on that I have the qualification as required under this rule from this university, this institute, this institute.
Right. Then you could have deferred your selection. That
Now, my lord,
your experience is surprising to us. We have to get clarification from them.
now that I say, my lord, that was very impressive to us. We were impressed by that. And one word is there, though you don't have any teaching experience, but the research experience which you claim, that compel us to accept. Now, my lord, admittedly, as on today, he don't have the qualification. Because the authority from where he is claiming, it says he don't have.
Check করলো না। Still looking at the correct সুপারস নোটিস করা। Application period to extend করলো। Pointers are also asked. You don't have the qualification.
Yes, my lord.
Then why were you desirous of initiating a disciplinary procedure?
No.
Yes, that is written in his lordship's order.
Well, that's well, may I? From very beginning, his conduct was not appreciated by the institution. For those purpose, so cause other things were there. We said we are going to initiate disciplinary proceedings. We did not work on that. Subsequently, issued another explanation. We are short for explanation regarding these qualifications only. He said so many things regarding the qualification. We made inquiry before from the authority.
Two weeks after the report filed for CO by LIC. They've allowed him to work for 5 years. Let him join. Did not video.
$315, it's an independent letter without having any nexus to the power conduct. 315.
Termination order.
No. 315, it's a letter issued to him regarding indicating deficiency of qualifications.
Where is your termination order?
Now, his termination order, it has paid Malad
29.
150 perhaps. 150.
150.
150. 8 years of research experience equivalent to that of assistant professor as defined in UGC/AICTE notification. One, the Gazette of India notification extraordinary AICTE the 1st of March 2019, which I initially referred to your lordship. And second is the UGC notification of 2018, which I have handed over. A letter by memo dated so-and-so 24th of July 2003 was issued to W. Hui, advising him to submit all appointment orders and relieving orders of research assignments undertaking during 2002-19 17 years claimed by him in his application, showing the pay scale, recruitment remuneration details. He was further advised to provide additional informations, evidence to establish that the research assignments held by him during 2002-19 were at the level equivalent to the level of assistant professor as AICTE as or UGC norms. After considering his reply dated 8th of August 2023 to this letter and the documents submitted by him, BOG in 29th meeting held on 12th of October 2023 resolved in principle to apply the provisions of relevant DOPT so-and-so to apply the provisions of relevant DOPT order so-and-so as he falls short of 4 years experience equivalent to that of assistant professor as per AICTE and UGC norms. Even after considering his postdoctoral research experience as equivalent to that of assistant professor, based on the claims made by Dr. Hui in his reply, BOG has also resolved to seek clarification on the aspect of equivalency of TRRA, these are his engagement at the research institution, as experience at the level of assistant professor for the purpose of appointment to the post of associate professor as per prescribed norms. Board of Governors in its meeting 30th meeting held on so-and-so by agenda dated so-and-so has considered all of the clarification received from University of Texas at Arlington, USA and Utah State University, USA, where he has been claimed a total experience of 40 months as TARA so-and-so. Now, from the clarification of both, noted that the experience claimed by Dr. Debrup Hui as TRRA or so-and-so are not equivalent to that of assistant professor as prescribed in UGC or AICTE norms, and that the Dr. Debrup Hui has repeatedly submitted false and misleading information. Therefore, Debrup Hui did not fulfill the minimum requirement of 8 years of research experiments at the level of assistant professor as prescribed in the so-and-so notification as cited above. Considering all of those aspects, but now the termination was there. So this is the only basis. Now, if your lordships,
allegation of false and misleading statement has been made.
Yes, in respect of this, because when he was asked to clarify,
this Mr. Jahan court observed that this is not a termination simplistic. That since the allegation is false and misleading statement has been made, this is a stigmatic writer, so that a termination is bad and reinstated. Your argument we have understood that still his initial appointment will go in the event it is ascertained that the experience shown by him is not sufficient for. This is your argument.
Yes, ma'am.
We are asking you that why you are opposing his reinstatement.
Now, restatement with all back wages.
And to advance your argument to that, this is the prima facie point we are doing.
Now, my submission would be, my lord,
His initial appointment is bad.
his initial appointment is bad.
He continued in service for 5 long years.
Yes, yes. Based on, my lord, may I place his claims before your lordship? What he claimed.
To reinstate, we will say that.
Or kindly come to page 303. 303. But he was well aware about these notifications of 2019 as well as 2018, which were applicable in this case. Now, he applied for this post with a claim, page 303, my lord. There are the second present position, your lordship got it? Now, bottom E, total experience in year and months, about 17 years in research field.
This is a wrong statement.
This is a wrong statement. Now, my lord, once again, he was asked to give clarification. That is page 57, prior to terminating him. Or kindly come to page 321 once. Once we got response to our explanation, show cause notice to the petitioner, we send the entire issue first to the Malad, Utah University, Utah State University. No. Now, after getting all these things, Malad, we sent letter to the UGC. Kindly come to page 325.
It was a request for clarification.
Yes.
That you did not open. And you terminated.
No. After this.
Yes.
After obtaining this.
No. What is the very...
Now the next page, 326. 326. The next page. It's a letter dated November 22nd of November 2023.
They say it does not come within our party.
This GTA or others, which he claimed that he has the experience, those doesn't come under the UGC. That
According to you is UGC's jurisdiction.
Yes. Now we wrote a letter to the AICT 327.
What did they say?
They said, my lord, kindly come to page 328.
Where is the relevant portion, Mr.
My lord, page 328, my lord. This with reference to your letter dated so and so on the subject noted above. In this connection, it is to inform that as per clause 2.25, counting of past service for direct recruitment and promotion is self-explanatory, which is reiterated as below. The provisions, the previous regular service, whether...
What you showed us from...
Yes. Yes. Now, my lord, when we matches his qualification and other things with that particular guideline, it shows no, he don't fulfill those criteria.
Where is that?
Madam.
That is your termination?
Yes, yes.
So no finding was either returned by UGC or by...
Yes, the AICT says follow this particular rule. Follow this rule. And this rule...
Whether this parameter is sufficient or not, that has been left to you to be decided.
Yes. They said you follow this parameter. Now, when we are matching that parameter, the reply of the Utah University, it clearly shows that he doesn't fulfill this parameter.
All right. Anything else, Mr.?
No, my lord, at present.
Yes. Millard, first of all, that he has possibly not shown, Millard, the page 303 of your lordship's brief. What is the declaration that has been made, Millard, by my client? What is the actual declaration? Page 303 of your lordship's brief.
Yes.
Yes, my lords. My lords.
In research field.
Yes, in this research field, and there is no whisper, my lord, that the qualification that he has claimed, my lord, that I have made certain declarations, my lord, which is fraudulent in nature, my lord. Your Lordship, I never said, my lord, that is equivalent to the post of assistant teacher, professor. So his understanding, my lord, with respect to his understanding and perception, my lord, these are absent, my lord, from the records. He said that I have claimed that I was armed with the qualification as that of, my lord, the assistant professor. Such claim, my lord, as per his perception, that is absent. There is no such declaration I made at any point of time, my lord. One must be confined to records, my lord, before one makes it.
17 years in research field.
In this research field.
It's not compatible with the qualification.
Now, my lord, this is a matter of inquiry. This is a matter of inquiry, number one. Number two, my lord, what is the question, my lord, that was asked to the United States and the university as well as, my lord, the UGC? Framing of question is very important, my lord.
Page 321.
Yes. Dr. Devrup, my lord's got it, my lord, 321. My lord, Dr.
121.
Yes, 321, my lord. Dr. Devrup, who has claimed that he had worked as such and such assistant during the period from such and such, and he has submitted copy of the such and such as proof. I am enclosing with these documents for verification. Please verify this such and such. And also for how many months? I understand that TARA part-time assessments and were paid on hourly basis but do not carry any pay scale. Please confirm. I understand that TARA assignments are given based on the recommendation of the faculty member of the department, but not subject to any open recruitment competition. Please confirm. Are the TARA assignments are considered as equivalent to assistant professor in terms of pay scale eligibility criteria? Please clarify. Now the answer was given on the 322. This is to verify that he was employed in the Wood State University as graduate research assistant from such and such. The WT form that was provided is correct. Research assistants are paid on case-by-case situation and are part-time assignments. Individuals are selected for position as a recommendation by faculty members. Graduate assistants are not equivalent to assistant professor in terms of pay or eligibility criteria. If you have any questions, then
Graduate assistant which we enjoyed was not any.
Not, I never said that I was enjoying the status of an assistant professor. I said, Millard, I was confined to Millard page 303. I said, Millard, that
We have 17 years
it's in the research field.
incumbent upon them to check it up.
Check it up, number one. Number two, Millard, who were the Millard selectors, Millard? The NIT, Millard, the premier institutions of this country, Millard, they sent selectors, they conducted the inter-selection. NIT Patna, that is Millard National Institute of Technology. So these are, Millard, also, Millard, these selectors, Millard, after verification of the declaration, Millard, found me that I should be declared as an eligible candidate as against the post in question. They selected me. Now, Millard, this person, the director, or Millard, the governing body or the board of governors, Millard, they sat over the decision and Millard has acted as an appellate authority. Now, Millard, there cannot be any element of uncertainty in the field of law subject to correction, Millard, when Mr. Jahan's client said, Millard, in the order of termination dated 24/1/2024, that the stigma, it is that I have suppressed something. My declaration is wide ab initio. It contains, it is fraudulent. Millard, itself, it is stigmatic. Once it is stigmatic, Millard, all other questions become irrelevant because there was no inquiry. Mr. Jahan, Millard, cannot say with conviction and confidence that he has dropped the proceeding. He has asked certain answer from me in response to the query made by him, and it was unsatisfactory. And accordingly, he has come to a conclusion. And discretion of inquiry, Millard, there cannot be any relaxation under the law. The law of the Supreme Court is a declaration under Article 141. And all civil and judicial authorities must come in aid of Supreme Court, Millard, under any circumstances. In this case,
If you are not having the
no, question is, Millard, if I am not having the qualification,
then it is
then Millard, no.
Disciplinary proceeding.
No, it is a disciplinary proceeding because my declaration which I have made, that is, there is an inducement according to him, which believed the authority, the selectors, to believe that I was qualified. Accordingly, a wrong decision was taken. Now, after 5 years, Millard, they found that these queries are required to be made, and the questions that were framed by the authority, while sending it to the AICT and UGC, there was no question which says that whether with this qualification as declared by Mr. Debru Bhui, the writ petitioner, whether he is a person to become eligible to the post in question. This was not the question. All other question, whether with this with this qualification. Well, query to the 327. No, 320, 25. Whether or not the experience of, sorry, Millard. Whether or not the experience of teaching assistant, GTA, / research experience, GRA, gained in university while studying in MS or PhD can be treated as equivalent to the experienced assistant professor required under the Rule 4.1(3) associate professor eligibility as per UGC notification number. Now, what is the advertisement?
No, if this is ultimately ascertained to be not fulfilling the qualification, Mr. Bose.
Who will ascertain? Faster. How it is to be ascertained?
That is the subject matter. We are asking you a question. Suppose today we reinstate you.
Yes.
And tomorrow it is found that you did not have the qualification.
Yes, because of the simple reason, the authority was under a duty to conduct an inquiry before termination takes place. If that is the mandate of law, my lord, the all other questions become irrelevant, subject to correction. The moment authority says that is prima facie, because the foundation, motive and foundation of the order dated 24/1/2024. That is why required to place only 2 judgments of the Supreme Court in order to be.
You are saying that if I do not have the qualification, you could have initiated a disciplinary proceeding for that.
I said, my lord, that the order of termination contains that my declaration is bad, which resultant factor is, my lord, that it is void ab initio.
Your declaration is bad. That was where it is stated in the termination.
No. Clarification, my lord, kindly see page 318. The Radyat Pak. 318. My lord, I categorically stated in page 318, may I read for my lords? However, the authority starts from, my lord. Second paragraph, my lord.
Yes.
Now, as well as the communication regarding these assignments were done through university's online systems and using university email, of which I don't have access to at present, I am unable to give those few documents at this moment. I never thought that I would be required to reproduce them anytime. I can only reproduce the communications done in my personal email. The authority, having done my PVR, knows that all these communications cannot be done in a span of 15 days. Had the authority asked for all these documents during recruitment, I could have gathered them and submit at that time only. However, the authority is welcome, and I request earnestly to verify every bit of the information I give here independently without my interference and chances of my many modifications, just like they did with my educational credentials. I can provide all necessary contact address. So as to summarize my experience, August 2007 to July 2009, TA and RA at the University of Texas, Arlington, Texas, USA. August 2009, December 2010, TA and RA at Utah State University, Utah, USA. June 11 to August 2011, Research Data Analysis Center of Atmospheric and Space Sciences, Utah University State of Utah, USA. the qualification part, my lord, that is, my lord, the UGC regulation 283, the AICT 283. First, my lord, transfer to 284, then I will come.
You are not answering our
Which one, my lord?
point.
My lord,
That if your qualification is doubtful, why should we
my
allow?
lord, doubt is not, suspicion cannot take the place of proof. It has to be proved to the hilt. Now, my lord, that is why the Supreme Court said without disciplinary proceeding means it commences with the issuance of a charge sheet. Without charge sheet, they could not arrive at a decision. That is the basic law.
So happens. Suppose there was no show cause against.
Yes.
Nothing was there.
Yes.
A clarification was sought for the qualification. You are
Yes.
eligible.
Yes.
Now, after obtaining the clarification, they could have said that you are not fulfilling the qualification. For that, any disciplinary procedure?
Yes, because I tell your lordship, after 5 years, after the professional period is completed, Lord, this initiation.
Terminated.
No, without any inquiry, that is the law. That is why I wanted to show your lordship Dipti Prakash and the GB Pant Institute. Yes, number one. Number two, this has to be.
Is it your contention that
I say
without obtaining clarification, suppose today a clarification comes, you don't have the eligibility. Then what will be the process? They will initiate a fresh discipline.
First of all, the ineligible. See, they said I am ineligible. Now, my lord, I was appointed 2019. Now, my lord, this finding of the authority, my lord, came at around 24/1/2024. It is a doubt that your eligibility criteria is doubt. Now, doubtful. Now, my lord, page 285 is the qualification. It has to be adjudged, my lord, in the context of the qualification laid down by the ICT as well as the advertisement. I will take your lordship's kind undivided attention to 3 pages. 285, that is qualification for associate professor. PhD degree, I'm sorry, my lord.
We are not on that, we are at the interim.
No, I said, my lord, if the doubt is not based on the document, then, my lord, this doubt cannot take the place of, it's termination. Article 1921, my lord. It is my fundamental right. Unless I am proved to be guilty, my lord, from the very beginning, my lord, I was ineligible.
To be guilty is one thing.
No.
Guilty will be if you have suppressed.
No,
You
no.
have not suppressed.
If I have not suppressed, my lord, that means my lord, it is civil consequence. My lord, I will carry this stigma, my lord, forever. That I was appointed somewhere else in institute where I made certain declaration and this termination, everyone will go through this. That is why I request your lordship that 3 documents, that the qualifications laid down by the ICT, it says PhD degree in the relevant field and first class or equivalent at either bachelor's or master level in the relevant branch and at least total 6 year or and. Qualifications, my lord, for associate professor, he has, my lord, tried to impress upon your lordship, my lord, by adding a certain thing which is not in the document. PhD degree in the relevant field and the first class or equivalent at either bachelor's or master's level in the relevant branch, and at least total 6 years, 6 research publications in SCI journals / UGC ICT approved list of journals, and C. Oh, sorry, page, sorry, my lord, I apologize. Page 285. 285.
This is AICT guideline. Not
Yes. But again, he is saying it is not UGC.
I say AICT.
Yes, I said. But kindly see the page 285, C1. Qualifications for associate professor. I applied against this post. For direct recruitment, PhD degree in the relevant field and first class or equivalent at either bachelor or master level in the relevant branch. This was also not disputed. He has not uttered a single word with regard to this qualification, and at least 6 research.
That, Mr. Vasu, we are only wanting your response to this issue.
What is that response, Millard? I put this question to myself that I should have been armed with the qualification of that of Millard assistant professor. I said these are absent. He had added something which is not in the qualification, not in the advertisement. Kindly have a look, Millard. He said, Millard,
will have no right to clarify the.
No, Millard institution has every right to clarify in the event, Millard, if it does not match with the requirement as asked for.
That
is exactly, Millard, that is not there. He has added, Millard, that I should have been armed with the qualification of assistant professor. Assistant professor. I request your lordship, kindly have a look to 5(2)(c). There was no such requirement. That is their perception, Millard, in the year 2024 when the so-called notice was issued.
Mr. Jahan has relied on the UGC guidelines, which says that it has to be equivalent to an assistant.
Yes, kindly see. I also, Millard, I answer. Millard, 5.1, 283. Mr. Jahan's understanding, page 283, minimum. Page 283. (5.1). My lords got it.
Jahan did not take us to that. Mr. Jahan showed us page 22.
No,
283, I am sure.
UGC data দেখাচ্ছে
5.1.
5.1, he has shown it. But he has not shown. He has shown, Millard, 5.
Was associate professor.
No, my post is associate professor. And 5.1 talks about, Millard, minimum qualification for direct recruitment as an assistant professor. 5.1. 283, 5.1, minimum qualifications for direct recruitment. And last, J, he has shown J, 284. But it has to be, he should have said that J.
283, Mr. Jahan has showed us.
284J, that the qualifications for recruitment, Mr. Jahan has shown your lordships. J, 284, qualifications for faculties in science and humanities. The qualifications for recruitment and promotions for faculty in the discipline of basic science, social science, humanities shall be as per UGC notification number such and such, guidelines issued from time to time. 5J cannot be, Millard, separated from 5.1, which talks about this is in relation to the appointment where minimum qualifications for direct recruitment as an assistant professor has been described. 5.1 never talks about, Millard, the requirement to the post of, Millard, associate professor. I hope, Millard, I am clear to my lords. 5J, 5.2 is, Millard, minimum qualification norms for direct recruitment promotion stage 2 to stage 6. Qualification for assistant professor senior scale. That is, Millard, different. I was then, Millard, taking your lordships, page 285C1 for direct recruitment, PhD degree in relevant field and first class or equivalent at either bachelor or master's level. And C, last, Millard, minimum 8 years of experience in teaching or research. First column, amended or read as, page 71. This is a post of associate professor, Millard, PhD degree in the relevant field for the direct recruits, amended or read as, qualification and experience, page 71, serial number 1, Millard, PhD degree in the relevant field and first class or equivalent at either bachelor, 4 years master level, in the relevant branch, at least total 6 research publication. Then minimum 8 years of experience in teaching / research or industry, out of which at least 2 years shall be the post of PhD experience. It is not Mr. Jahan's submissions, Millard, from records that I have, Millard, defaulted in achieving, Millard, this one of these criterion, Millard. This is not the case.
The AICT guideline which is being referred.
Assistant Professor.
Yes, what you are saying? You said that initial appointment was bad.
304. 304 declaration is there.
Associate Professor experience is no bad.
304 must
Assistant Professor.
The AICT says also assistant professor at page 229. So skipping that.
To be at 2029. But one must go by the advertisement and the regulation.
Yes, the regulation says so.
So what, I did not make any wrong declaration.
304. There is nothing wrong with that. Because that has to be how on the basis of a still attaining the finality on this issue. How can you throw him out after 5 years? That is according to you, but not according to the records. Somebody has to adjudicate. You don't have the minimum criteria or qualification considered. But one aspect. But there must be some relaxation. So-called relaxation has been given to the. Our question is, has there been a finding today that you don't have the qualification for the post? There is no finding. There is some confusion. Confusion. On the basis of confusion, after utilizing 5 years of service, you will throw him out. Not kindly consider one. We are at the appointment is not absolutely contrary to the appointment will be void ab initio in the event it is determined that he does not fulfill the qualification. Prima facie not it has been observed. Prima facie not it has been observed that he is not having requisite qualification. And not only not highly aspect another matter. Another side of this point. Point is not today not if genuine candidate must have been not overlooked. Not it is a violation of Article 14 of the Constitution of India. So like at the time of giving initial appointment, Lord, he has been given appointment, but on the contrary, there are some other eligible witnesses are there. They are deprived of. With suspicion, a man be thrown out. But this is not a case of suspicion. Not it is it's not at all a case of. Please show us where is your finding to that you don't have the qualification. You are appearing for Union of India. Yes. Show us which is the document which says that you don't have the. Not document could correspondence. Not we are wanting a reply to this. Yes, reply of yes. Is their communication. Wanting to you are for Union of India, na? Where is your memo showing that he does not have this work? Whether you were the selector. I am not a selector. NIC there is a special act, not National Institute of Technology Act. But Ministry of Education is supervisor. Code of Governance is not an independent body. NIC is an independent body. Section committee, your representative was there. No, I am not there. That is what I was told. You were told. NIC representative was not there.
I said NIT, Millard, the NIT when it conducted the selection process and the selection committee was constituted at the behest of the NIT. They were all, Millard, the teachers in NIT. He is from the, now Millard, I said.
But governing body is the appointing authority. Now, Millard, we some persons to be the selector, it from NIT Durgapur, from the NIT Patna.
Millard, first of all, Millard, all the authorities excepting Mr. Jahan, nobody has responded, Millard.
You reinstate him, don't pay the back wages. His reinstatement will abide by the result. In the meantime, you just record that not the body competent, they have said it is for the AICTE to consider. But AICT's council is not here. We are keeping it on the next day. Come and say.
Kindly pass an order upon the ICT itself. Even in their absence, this can be passed. Let them file a report, it's not any adverse order. So it will, yes. Let them file that report if your lordship on the next date.
No, Millard, that is Millard, absolutely Millard misconstruction. Millard, Millard, he is resorting to the last resonance of your lordship's observation on the Millard last. Millard, that is no. I have never said it is a.
Yes, my lord, kindly.
Record that he has made this appeal.
No, Millard, Millard, the intention was.
At your present salary, your appointment will be published the result of.
But the AICT is on the authority, Millard, to conduct an inquiry. Millard, the disciplinary authority, first of all, your lordship, I made a submission.
They are asking them to come with a report as regards the qualification. Then we will decide, you make your argument. The president has been referred.
Part hard, my lord, not.
No, the joint prayer, I'll make it.
We don't know whether determination remains on. It will appear
May I have your lordship kind leave to mention lordship before my mentioning that this the urgency is the counseling to be stopped by 29 to 3rd of October lordship. Due to the grave urgency, I am only praying to leave the memorandum of appeal without certified copy of the order. 18th of May lordship. Just May on Thursday.
September.
September. 18th of grateful.
My lord, in this fixed matter, my lord, one small correction is required, my lord. May I hand up to your lordship? Only, my lord, we are for appearing for the respondent writ petitioners and 5, 6, 7 in MAT that I have corrected. My lordship would be pleased to. ও আচ্ছা দিচ্ছি বাবা দাঁড়া এটি করাই হয়নি এতগুলো করতে তো মানে that correction is required my
Tanda is no good. Tanda Partoda is no good.
5, 6, 7 in 890 that in MAT. My lord would be pleased to kindly, my lord. My lord, clients have.
Applicants in Can 5.
My lord, in 5, 6, 7, that is in connection with the MAT 890.
Can 5, you are adding respondent naturally.
Yes.
To the
My lord, it is all written in 873 as in. Kindly see, my lord. If it is not written, it will be assumed.
In MAT filed in connection with 873.
No, it is with the 890. MAT 890 and 11, 10 and 11 is 873, my lord. That is rightly been written.
What has been gone down in the cost title? Cost title it is
Cost title is the same, the which I have corrected, that is written.
there.
Yes.
So very good. What is your
My lord, it's a part of the order, my lord. My clients,
part of the order?
your lordship kind enough to ask, my lord, if your lordship kindly correct.
It's not expected for the silly errors of non.
If your lordship kindly. No, well, I can pray before your lordship.
No, not required.
As your lordship pleases.
Yes.
May it please lordship, since objections were taken, I shall not take your lordship through the paper book pleadings. This is very important.
Just give it.
মানে পেপার বুক থেকে দেখাচ্ছি
Tanda to
That's-
private party.
দাদা পেপার বুক হচ্ছে তো বোর্ডের
Eight seven.
Right?
এই ক্যানগুলো 890
My lord kindly takes up the paper book filed by the West Bengal Primary Education Board. But I'm really challenging the action of the board. Therefore, the pleadings of board would be important. No other pleadings. Kindly come to paragraph 9. I just take your lordship through few paragraphs. Page 38 of the paper book.
তোকে বলছে বন্ধু আছে বলে যেতে ভাই জায়গা তাই কতটা জায়গা আসলে পিছনে অ্যাসিস্ট্যান্ট 890 দিয়ে দিয়েছি
এমএটি 873 এমএটি 873 আর অন্য সব কাগজ ছড়িয়ে দিন কোনো একটা কাজে লাগবে না
পেজ 30 মিলছে না বলছে
873 টা দেয়নি
আমারটা তোমার কাছে চলে যাচ্ছে আমারটা তোমার কাছে চলে যাচ্ছে আমার
14th of September 2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. It is needless to mention, is important, that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have training will be considered too. Notification proves that the board decided to get benefit of relaxation to take 24 qualified candidates. I shall place this notification later. Then paragraph 10 is important. Your petitioner states that after notification, the procedure was started for appointment, and from October to December, the interview and verification process started, and on 31st of January 2017, allegedly, the result was declared, but there was no panel. There was no merit list. There was no category-wise merit list. No division of numbers and or rank was given to anyone. In website of the board, there was a dedicated space where a person could see whether he or she was empaneled or not. No merit list was ever published. And in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 30th January 2017, list of trained candidates were published. On 4th February 2017, list of non-trained candidates other than the Bengali medium was published. And on 8th of February 2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and list, it is clear that all trained candidates of 2014 were appointed to the first list. And after completion of the same, as per notification dated so and so, the board appointed non-trained candidates. Then Lordship may come to paragraph 11. Just I am reading out, Lordship need not be detained for that. In paragraph 11, down the middle, it is alleged that thousands of non-trained students were appointed and petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law. Then paragraph 12. Your petitioner state that recently TET 2014 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this honorable court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferers of this scam. On 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated that the candidate should possess qualification as per guidelines of NCTE. Such notification is illegal. I am just skipping over. Then Mr. Y was empaneled. A person named Mr. Y having roll number such and such was empaneled by the board. It also proves that huge corruption took place. As per the action of the board and as per the different statements given by the president of the board, Mr. Swanso, all trained candidates were recruited. And as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. Then paragraph 13.
Then what was the allegation of the petitioner? 2014 was corrupted. It is your allegation.
State 2014 corrupted, and even the selection process were.
Paragraph does not say so.
Yes.
Paragraph says that it is state 2014 corrupted.
And then followed by, if I may, followed by they say, yes, once again, Milord, kindly come to paragraph 11. Several non-trained candidates were appointed.
Yes.
Now, the Lordship will go by the principles of a deemed pleading. I shall satisfy from authorities that the court, whose duty is to, Lord, find out the truth, should not strictly confine to the words of the pleading, but they have to also consider the deemed pleading. Here, pleading is categorical. Apart from 2014, where CBI investigation is going on, I shall also place the CBI charge sheet. Even in case of selection, non-trained candidates were appointed. Then below paragraph 12, about example given to Mr. Y. Now, this Y is relating to recruitment in 2016 selection process.
So if it is to be deemed that the 2016 process was also under, then where is the prayer to that effect?
Yes. Now, may I place little more?
Just a question.
Yes, Lord, kindly come. Let us come to the prayer of the repeat. No, it's better to satisfy the queries of the court first. Lord, kindly come to the prayers in detail. I to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from date 2014, including the date of recruitment. Then direct the authorities to treat the petitioners equally with non-trained candidates who have been recruited by the board after expiry of the relaxation period.
That we understand.
Then kindly come to Lord 4.
By giving the same benefit.
5 is important. To direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment.
TET 2014, you are qualified.
Oh, sorry, Lord, I skipped Roman 4. To recruit the petitioners by giving them same benefit by which other non-trained candidates were recruited by the board following the rules dated 22nd March 2016 and appointment notification dated 26 September 2016.
So your challenge was that either give those persons or give the similar benefit like the untrained, non-trained candidates were given.
Okay. But my prayer is everybody is charged. To recruit the petitioners following the appointment notification dated 26 September 26, very important.
So what is the kindly address us that on the basis it seemed to us as it was argued that TET 2014 allegations are there, nothing to do with the selection.
Yes,
and that they would be satisfied in the event They are given appointment like those non-trained in the remaining.
No, but my argument would be, it might be not hurt many, that when the court finds there is many institutional corruption, systematic fraud played, starting from 2014 to selection, then I shall develop that. Now, to maintain the purity of the system and keeping Article 14 and 16 in the mind, court will be non-hesitant to set aside everything and do it afresh. Number yes. Now, I am just to complete the paragraph
12.
12. I have given the instance of why, then 13. Your petitioner stated a candidate, namely Prolay Sarkar, was not empaneled. Another candidate named Dhiraj Bandyopadhyay, having roll number, was not empaneled. Vishwajit Burman, having roll number, was not empaneled. But they were called by the department for verification of documents, and from sources, the petitioners came to know that they were working as primary teachers. Look, this is fundamentally attack on the entire selection process. Look, how these were dealt with by the affidavit, I shall place it. Then this paragraph 13 says there was huge illegality.
Paragraph
13. Though there was huge illegality in the whole selection procedure of, it should be not 2014 selection process 16, and everything happened as per the wish of the board. And for this illegality, the candidates like the petitioners could not get appointment as primary teachers. Therefore, this relates to the selection.
Yes.
Then we learn a serious allegation in paragraph 15. Your petitioner further states that on 30th April, so-and-so, I am not naming, made a statement before the media pointing irregularities in TATE panel. Recently, a person lodged a complaint against one MLA of All India so-and-so. That MLA took crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of one another MLA was arrested. The Constitutional Court would definitely not go deep into it to do complete justice and uphold the constitutional principle. Then paragraph 16, your petitioner stated that the TATE 2014 examination is the biggest scam in West Bengal since 2011. Then Lordship may skip over paragraph 17. Your petitioner states that TATE 2014 is the biggest scam of the education department, so-and-so. MLA, MP, leaders of ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, petitioner came to know that roughly such and such amount was given for job in TATE 2014. Well, a job cannot be taken. And now continuing paragraph 18, the statement is made an absolute fraud was committed by the West Bengal board by not publishing merit list in respect of, it should be without selection qualified candidates. Without paragraph 18, last two lines.
Yes. Merit list of TATE 2014.
Well, 16, selection 6. Then kindly turn to, my lord, paragraph 22. My lord, 22, my lord, last three lines. I am not reading the entire thing. Your petitioner states that the respondents and each of them acted illegally, arbitrarily, and unconstitutionally in appointing some candidates who did not even sat for TET 2014. Serious allegation. Now, my lord, from the cans which were admitted by the court, I have prepared a list only to show that how many rank jumping was there. I shall place that. I have given them the copy also. Now, in the background of this pleading of the writ petition, now kindly takes up the affidavit filed by the board. That is in Millard, volume 2. Page 359. Now, that I would make this submission, probably it might be repetition, that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3. I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Then based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records, it is apparent that the aptitude tests were held. He wants to draw an inference on the basis of what? Since marks were allotted. Then paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, would please to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. Then the interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, Millard clearly admits Then kindly come to 363, another affidavit by the president. Here, my lord, he describes from several authorities what aptitude test mean. I'm kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12.
It's 325. Evidence. 375.
The second direction contained in the order dated 24th of January 2023, passed by this Honorable Court, directs me to submit the list of interviewers at page 375.
I'm just wanting to see the 24th January order.
Yes, 24th January order, my lord, he was directed to file affidavit explaining the situation. 24th January order, my lord.
Yes.
The page 423, I am thankful to my friends.
Yes, Mr.
Yes. But the order says, in course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test, there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under 165. Oath to 7 of such candidates being so and so, this is the order.
Yes.
Yes.
Now you are showing us paragraph 12.
Yes. The second direction contained in the order dated so and so, passed by court, directs me to submit the list of interviewers who interviewed, took the aptitude test, so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview viva voce aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took viva voce aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no method was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmakar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to page 389, paragraph 9 of the, sorry, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in the petition. Now, this is an admission that they did not do so. They say that we have not been done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 14.16, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks for candidates who were recommended from the 2016 recruitment process.
2022.
And that too, my lord, in terms of order dated 2022. And that's not the complete list.
Page 389.
389 to bolla. My lord, then paragraph 10, as I said, my lord, the defense of the recruitment authorities not to come up with records and say petition is not maintainable. I say that till paragraph 10 of the said petition, in paragraph 10 of the affidavit, the alleged grievance of the 140 petitioners were those which centered on 2016 recruitment process. In paragraph 11, the petitioners are dipped into 2020 recruitment process and made certain amendments. There is no amendment in said petition. 2020, we are not concerned. Then, in the 2020 recruitment, no untrained candidates are eligible to apply. That's not our grievance. Our grievance is 2016. Kindly come down to, my lord, 3 lines from the bottom. On the date of affirmation of the said petition, I got it. 4 lines from the bottom. On the date of affirmation of the said petition, the petitioners are all untrained candidates who were unsuccessful in the 2016 recruitment process. In such view of the matter, the petitioners, as a matter of fact, not made out any case which calls for an interference by the Honorable Court. No denial of allegation of fraud and, all scam. Then, petitioners have failed to demonstrate existing any judicially enforceable legal right or breach in performance of any respondent legal duty warranting issuance of mandamus by this Honorable Court. It is categorically denied that the answering respondents intentionally ignored the petitioners as alleged or at all. It is categorically denied that although thousands of untrained candidates were recommended, The petitioners, those similarly placed, were ignored as alleged at all. It is categorically denied that the relaxation given by NCT is applicable to all TET 2040 candidates who qualified TET as alleged at all. On the contrary, it is stated that the relaxation given by the NCT applied to those applicants who applied for the recruitment process. This is a fraud on statute. I shall explain. Then will kindly skip over. I am not detaining with further readings. Page 392. Well, at 4 lines from the top. Unless further details. Now, now the burden is thrown upon the candidates that they have to get all details. Unless further, got it? Unless further details are furnished by the petitioners pertaining to alleged Mr. Y, having roll number such and such, the answering respondents are unable to deal with such statement temporarily, reserving their right to deal with the same subsequently upon disclosure of further details. What nonsense is it? Records are with you. You are privileged with the records and you want me to produce it. Is that the law of evidence says? The answering respondents have no knowledge about the alleged different statements given by his previous president and accordingly refrain from making any comments thereon. Such refraining, it is made abundantly clear, is not an admission of the statements. The answering respondents further say that the petitioner failed to establish that there has been any pick and choose between the candidates. I have given 2-3 examples. You could have come up saying that his marks is X. We have given appointment to Y. Y is higher than X. And now there are 100 petitions pending before this court. To summarize everything, I have just prepared below the chart of rank jumping. I shall hand over to it, your lordship. This is the affidavit in detail by the board. Kindly come to the paragraph 19. The specific pleadings in the writ petition when they were touched. It is stated that by the order
Page 395.
396, paragraph 19. It is stated by the order dated 20th December 2022, this Honorable Court directed the answering respondents to come up with the particulars in tabular form. The marks obtained by last empanel candidates of different categories and different mediums of all districts. In compliance thereof, the answering respondents with a memo dated so and so submitted the list of petitioners along with the breakup of total score together with the breakup of total score of the last empanel candidates in the respective medium, category and district wise. The said direction was furnished in a tabular format before the Honorable Court. Such report is annexed. It is then, if upon examining the said tabular chart, further queries are required to be addressed, the answering respondents are willing to explain them. Is it not withholding? The court will direct, then only you come up with your defense. The answering respondents categorically deny that the report is absolutely bogus as alleged at all. It is clarified that if at any stage of the selection, any ineligibility is detected by the examining body, then the candidature of the applicant can be rejected at any point of time. It is not a correct appreciation of the position of law that if at the time of scrutiny or verification a candidate clears his scrutiny verification, he or she cannot be declared as ineligible before or even after being recommended. In other words, if a candidate upon crossing the hurdle of scrutiny and very is permitted to sit in the interview aptitude test, the right of the examining and recommending body to recheck, revisit the candidate eligibility is not wiped out. Any allegation against such a contention is emphatically denied. Furthermore, a candidate is rejected, the examining body is obliged to inform him the reasons, see the audacity. The reason of such rejection under the applicable statutory rules. It is categorically denied that the report filed by the examining body is absolutely bogus as alleged at all. It is further denied that the report is absolutely false as alleged at all. Well, the denial is that it's not absolutely false, partially false. The Deputy Secretary of the answering respondents complied with the order of this court. Then, my lord, will kindly come to paragraph 20. I say that not with respect of one candidate, Noor Huda Khan. Yes. In the present proceeding, where the prayer is for treating the writ petitioners equally with recommended non-trained candidates, the issue may not be gone into. However, if this honorable court passes a direction, the alleged ambiguity pertaining to Noor Huda Khan can again be looked into by the answering respondents. It is categorically denied that intentionally marks of the petitioners were reduced while submitting the report of before this honorable court. Certain RTI query answers are cited to demonstrate that the incorrect report was submitted. Such RTI answers keep to be thoroughly scrutinized if necessary before arriving at any conclusion. But does it not show that the authority was trying to evade the responsibility? These are the pleadings. And if your lordship really goes by this pleading, what is the outcome of it?
The relaxation.
Outcome is there has been allegations by a candidate of gross irregularities, corruption, fraud, and the authorities filing affidavit says we are answerable only when the court asks to answer, not otherwise. নোটিফিকেশনটা কবে হয়েছিল? না, এক টাকা তো রুলসটা।
Relaxation notification.
না না, রিক্রুটমেন্ট নোটিফিকেশনটা।
এই রিক্রুটমেন্ট নোটিফিকেশন।
ডেট কবে জানো?
26শে সেপ্টেম্বর 2016।
নাকি? Now, my lord will kindly take the trouble to come to the recruitment notification at page 120.
Pertaining to this candidate why an explanation was given, which was submitted before us.
So it was here.
Ask your junior to just to recollect, we have taken that on record. That what is your why was it was so far as I remember, candidate why the name was not given. Subsequently, document was document. That submitted by Mr. Sen.
Because of the internet features, my lord, the full name was not given by the candidate.
This was a reply on their part. So please,
The full number was there.
Yes.
I shall see their reply. Kindly turn to recruitment notification. At page 120. The copies you may need a microscope, but I'm just reading out. Lordship may only say date. This was dated 27th of September 2016. Date is important.
Page 120.
20. Does the Mitra got it?
I have a better copy.
Oh.
Yes.
Can you note the date? Nothing else. 27 September 2016.
26.
26. 26. Anyway, I am not able to read it.
Yes.
And this notification was issued on 26 September 2016. And let us see what was the relaxation given by the NCT for non-trained.
Page 95.
Kindly turn to page 95. Clinic থেকে দাও সাগরদা দিয়েছে কি দিয়েছে দরকার নেই Yes.
Relaxation was extended, Mr. Bhatia.
I'll come to that. Therefore, on that date, there was no relaxation.
On
26th of 2016, there was no relaxation. Relaxation came to an end. Kindly come to page 95.
Yes. Page 95, yes.
Yes.
Relaxation up to 31st March 2016.
Yes.
Yes, subject.
Yes. Relaxation was up to 31st March 2016. Therefore, on the date of notification, recruitment notification, the relaxation was over. Therefore, no one who was not qualified on that date could have got the benefit of relaxation. Now, I will come subsequent amendment. Therefore, on 26th of September, the relaxation granted on 9th of April 2015 had no force.
Three proviso course.
Yes. That's our point, I argue.
That has not been the case in the petition.
I would again say, Milord, it's pure.
This was never a point in the
Milord, it's a pure question of law.
Government trusted we took note of that submission. But Mr. Bhattacharya, in the writ petition, the argument which you are making is not there.
Yes.
There was no.
I have read it.
Which was that line?
I have read it. I just.
Expiry after
So
expiry.
I have said that there was no relaxation. I have said so in the petition.
So relaxation, you are building that argument, Mr. Bhattacharya, with support of some element.
Yes. Kindly come to Milord the writ petition pleading.
Yes.
I just read out that there was.
Let Mr. Das to check it up. Proceed.
Yes, let's proceed. Now, what is their defense? I again say it's a pure question of law. On that date, whether the relaxation was available. What is the defense of state or the authority that there was a subsequent amendment of law? I take your lordship to that.
Mr. Bhattacharya, suppose this relaxation was not there.
The many could have not applied, considered at all.
Relaxation was not there, then the 6.3 provision does not come. That is 6.3 says that you don't have the required training, you have to complete it after appointment within the specified time. 6.3 has not been assailed in the.
No, that 60, in deepest of respect,
Correct.
kindly come to 6.3.
Yes, page 130.
Sir, paragraph 19, that paragraph 9 and 9.
Now, so for the first thing will answer the paragraph 9 and 19, we have said there was no relaxation.
9 and 19.
If 26 September says, advertisement says, that is in terms of the 2nd of March rules. 2nd of March rule says that if anybody is without this training, you has to complete it within 3 months.
I'll explain that. It's not the correct.
This thing goes.
Everything goes.
এক মিনিট বলবো স্যার, এক মিনিট। এই রুলটা রিল্যাক্স পিরিয়ডের মধ্যে, কিন্তু নোটিফিকেশনটা হয়েছে রিল্যাক্স পিরিয়ড এলাস হওয়ার পরে, সেটা বলে দিয়েছে। 2nd মার্চ রুল ফ্রেম হয়েছে, 31শে মার্চ পর্যন্ত রিল্যাক্সেশন ছিল, রুলটা ফ্রেম হয়েছে রিল্যাক্স পিরিয়ডে, কিন্তু নোটিফিকেশনটা হয়েছে আফটার এক্সপায়ারিং দ্য রিল্যাক্সেশন।
Without one explanation which comes as reasonable, that when 2016 rules was enacted, এটা কোথায় আছে দেখো,
এই 2016 রুলস সেম বিনি রুল পেজ নাম্বার 111, পেজ নাম্বার 111।
immediately satisfied.
Paragraph 9.
No, paragraph 9 is pleading. That's the clear pleading.
119.
111, that's the 2016 recruitment rules.
Yes.
Kindly see, the rule was published on 2nd of March 2016.
After the relaxation, according to you, was what?
The rule, when the rule was made, then relaxation was available.
Yes, yes.
And that's why 6.3 was incorporated. Now kindly read 6.3.
So your contention is that after publication of rules, this relaxation was no longer there.
Yes, on the date of notification. Issue is, when you are inviting application, then there was no relaxation, valid relaxation. 6.3, which is troubling, my lord, wouldn't have troubled had this notification, my lord, and completion of recruitment process done within the period of 31st of March or 31st April, 31st March 2016. 2nd March 2016 is within the period of valid relaxation. That's why 6.3 says,
so your contention is on the date of advertisement, relaxation was not subsisting.
it's not subsisting. Therefore, the relaxed candidate wouldn't have been at all allowed to participate at all. Now,
Including you.
maybe. Well, I am. One thing, my lord, when your lordship is considering the question of public employment, my lord, this is not a one-to-one issue. This is issue of, my lord, whole recruitment process being conducted, my lord, following the principles. Now, here, lordship will kindly, what the state government's, my lord, stand is, as I understand, my lord, from my juniors, that there was an amendment of law in 2017. Kindly takes up that amendment. But this is a part of that I'm told compilation by one of my learned friends.
এই বইয়ে অ্যামেন্ডমেন্টটা আছে, অসুবিধা হবে। আরেকটা বই নেই?
তোমাদের কারোর কাছে রাইট টু একটা বই আছে জজ স্কুলের? এমনি
Milord, this is very important, Milord. Amendment of law, which is the probable defense of state.
এটার থেকে পড়ছেন তো এই জিনিসটাই কোর্টে দেওয়া আছে, অন্য একজন কাউন্সিল দিয়েছিল, সেটা বলে দেবে?
কোথায় আছে?
সাগর বন্দ্যোপাধ্যায়, সাগরদা দিয়েছিল পেজ নম্বর 1, ওটা দেওয়া।
But I am told, Milord, this is a part of the compilation filed by Mr. Shagor Bandyopadhyay.
23(2) was argued.
Not 23.
Kindly come to 2017 amendment of the act.
সাগর বন্দ্যোপাধ্যায় কে আছে?
এই কম্পাইলেশনের মধ্যে আছে দিনদাস।
না না, এই বইটাতে আছে, এই বইটা। আরে কম্পাইলেশন থেকে এই কম্পাইলেশনটা দেখি।
জজ সাহেবরা কম্পাইলেশন থেকে সুবিধা হবে।
No, no, it is there with us.
Kindly, may I just place it, or should we immediately get it?
This section 23.
No, this is the
23
amendment of Right to Children Pre-Education Act.
Section 23 provides. Second clause.
Which paragraph you are
That it shall be deemed to have come into effect on the first day of April 2015. That is the retrospective effect given. In 2017, law is made. Retrospectivity is from 1st of day of April 2015, not beyond that. But I am reading, Lord, kindly come to section 1 of the amended act.
স্যার ওখানে পাবে না, অরিজিনাল একটা প্রিন্ট করো।
তাহলে কেন ওটা দিলে? জশাই যে বুঝতে
বলছি এটা বের করছো,
না
আমি সেটাই তো আপনাকে বলছি স্যার।
ওইটা কম্পাইলেশনে বার করে দিতে
বার করতে বলছি আপনি।
What you are saying, Mr. Das?
Well, that book will not really reflect that. But may I read out for your lordship? কোনটা দেবো? এটা মার্ক করা? কি যে করো না।
এখানে সাগরদার কোন সাগরদা যে একটা কম্পাইলেশন দিয়েছিল, যে কম্পাইলেশনটা দিয়েছিলেন।
So already keep this as your next argument?
Yes. So I'll just give the point.
You have already mentioned to us that on the date of the advertisement, there was no relaxation.
No relaxation, but the defect of state, that's why I'm pointing this. State government will not, the appellant rather, have argued, I am told, that this defect was removed because of the subsequent amendment. I want to show that defect was not removed by subsequent amendment.
দেখি এটা দিয়ে দাও জজের শেয়ার, এটা একটু দেবেন। আরে ওই অ্যামেন্ডমেন্ট এবার
kindly amendment brought on 9th of August 2017. But it shall be deemed to have come into force on the first day of April 2015. But therefore, the act was given retrospective effect vis-a-vis 1st April 2015, not beyond that. And then it says, provided further that every teacher appointed or in position as on 21st March 2015, who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the Right of Children Free and Compulsory Education Amendment Act 2017. There were the persons who were in a position on 31st March 2015. That is the retrospectivity. Here the notification is without June 26th of September, sorry, not June.
September 26th.
There were the persons who were not qualified, they were not in a position as on 31st March 2015. If they were appointed, they have to acquire qualification within 4 years.
নোটিশটা করেছেন, শেষ প্যারাগ্রাফে বলা আছে ইভেন যাদের রিল্যাক্স দেওয়া হয়েছিল ওই টাইমের মধ্যে তাদের 2 বছরের মধ্যে ট্রেনিং পাবে। এই তো পেজ নাম্বার 99 ভলিউম 1।
Come to me that the original relaxation given at page 99.
Page 99.
Yes. Now, this was a notification by which relaxation was granted. And my lord will take the trouble to come to clause 7 and subclause Roman 6. The state government got it.
Page 99.
9.
It is a part of the.
Yes, but this is the, I am referring to the clause 7.
Of a notification.
Yes.
Of 1st April 2020.
Right. This is the first where the Right to Education Act describes qualification.
Yes, what your argument?
May I kindly come to Roman 6 of clause 7.
6 years.
The state government and other school management shall ensure that teachers who are appointed under relaxed qualification norms acquire the minimum qualifications specified in NCT notification within the period of 2 years from the year of appointment. This relates to the persons who were appointed by virtue of relaxed qualification. They were mandatorily required to earn the qualification.
This is before the.
This is before. And that's showing, therefore, relaxations are always for a particular period to ensure that the people may come up with their training qualification.
Then what happens to Rule 6?
Rule 6 becomes Rule 6 becomes redundant. No prayer is called for. With notification, now the notification is at a point of time.
So you are now challenging the rules also. Having participated, you are now challenging.
I am not challenging. I am not explaining the effect of rules.
That it is a redundant provision according to you.
According to me, the notification was issued at a point of time when their relaxation was not available. Rule was made at a point of time when relaxations were available. I am trying to interpret the law in the context of the relaxation granted by the central agency. My lord will read Sux 3 at a point of time when the rule was promulgated, when relaxation was valid. They ought to have completed or ought to have invited the application within the validity period, which they did not or could not. When you publish the notice, then there is no provision for relaxation. Therefore, Rule 6.3 automatically becomes non-applicable.
Now was not there in the literature.
Yes, it was. It was. Kindly come to Milord, paragraph 9. Milord, I have started saying that this is a constitutional court. This is not, Milord, civil dispute between two parties. Milord, kindly come to paragraph 9. I am reading out. Well, I have placed it.
Is when the advertisement was published, when the rule was published in March, that was in March, 2nd March 2016.
Then the relaxation period was valid till 31st of March 2016, sorry. They could have immediately invited application.
Validity was there. Because it is within 31st.
Yes.
At the time of advertisement, there was no validity.
No validity. That's problem.
As such, 6.3 becomes redundant.
It's not applicable except with that notification. I can't say redundant. If that was issued within the period, it was valid.
Recruitment এখন ওই রুলেই হচ্ছে কিন্তু ওটা
Now, my lord was putting me whether there was any pleading. Yes, kindly come to me, lord.
Paragraph 9, no relaxation.
9 and 19.
9 and 19 both.
Yes.
And this was never dealt with in the affidavit subject to correction.
No, not dealt.
Not. Now, these are the foundational facts. I don't trouble you lot anymore with facts. And I have not placed the affidavit filed by the agency. Now, the agency says, what করছো কেন? The agency says that aptitude tests and other things were done by TPSCs at the district level. That's their affidavit. Was any legal existence of DPSC then? Now, kindly see the constitution of DPSC.
Page 31.
On the date of the time of acquisition, there was
Now, kindly come to me, Lord. Chapter 6 of the Primary Education Act 1973. দর্শকদের দাও এটা লেটেস্ট তো
হ্যাঁ একদম
So kindly come to me, Lord, section 37, the primary school councils. District primary school council, state government shall, by notification, establish for each district, excluding the hill areas and the areas included in Calcutta, with effect from such date as may be specified in the notification, a district primary school council bearing the name of the district and for the subdivision so and so. Provided the state government shall by notification establish for the subdivision of Shiliguri, I am not troubling my lord, then a district primary school council shall consist of the following members. But all these categories are mentioned. On that date, none of these categories representation was there. What was there? Kindly come to subclause K, chairman to be appointed by the state government. Now the chairman to be appointed in a council. The chairman cannot be bereft of any council. But I read the K, 2K.
Chair.
37.
At the top also the chairman who shall be appointed by the state government. Now everything was done, chairman as persona. And that the existence of the primary school council was not there, has been held by this court just a few days back, and a single judgment having persuasive value. The দুটো কপি দাও সাহেবকে
পূর্ব মেদিনীপুর হাওড়া যেটা কোনো লাভ $37 এর আবার কপি দেয়
of the judgment, the detailed constitution and the methodology. Then kindly come to paragraph 28. This was the case of Purva Midnapur, but the similar is the case for all districts. But I am told Midnapur and Hooghly judgment also there. The records reveal that the District Primary School Council Purva Midnapur was last constituted pursuant to notification dated 21st February 2011. Its statutory tenure of 4 years expired in 2015. But no election or reconstitution of members has taken place thereafter under section 40 or 41 of the Primary Education Act. Consequently, since 2015, no legally functional council exists in the district. The same judgment will covers for Hooghly and but we have got the report of different districts. My lord, may not be jumbled up with documents, but fact remains, my lord, none of these primary district school council had been reconstituted after the expiry of 4 years from the first constitution. I think Mr. Shanial Millard can enlighten if he can show that there were, at least in a particular district, this point may not be applicable for that district, but this is common everywhere. If even Millard, the affidavit which says that this is done by the district school council is also travesty of truth. আর ফ্যাক্টে কিছু বলার আছে দাঁড়াও এটা শেষে এবার জাজমেন্টটা দিয়ে শুয়ে ডিম প্লিডিং
Yes.
Now, Lord, I shall cite authorities on few points. Lord, I was told that a thorough argument was advanced. How could the learned judge get these documents under section 165 of the Evidence Act? Where is corruption? Because corruption doesn't mean only the exchange of money. Corruption, Milord, means the action done in violation of rules to favor persons. That is also corruption. Now, while your lordship will be going to that, আমার তো নোটটা ছিল আর ইমপ্লয়েড নোট না বাড়তে যায়
Evidence Act. Six. The judgment was six.
But I will place this in detail, a little detail, not in exhaustive, this huge judgment.
So before you go to that, this amendment, there was an amendment to the rule itself. This that in every district primary school council it has to be published. That amendment.
Centrally. Now it was amended saying it centrally it will be done. But this is not a point. They say the aptitude test and everything was done district wise. In the affidavit. I will just press it.
Yes, district wise.
Therefore, district wise by the district councils. The center doesn't say. It says we don't have any record. We don't have any record of districts. We have only a list of the.
Has conducted it centrally. That was the amendment.
Centrally selection now instead of the councils, the board centrally would do. There is no quarrel with that.
Then that means that there will be no district-wise interview.
Kindly come to the
Any application was made for district-wise appearance.
kindly come to their own affidavit. That's why please.
Answer to our
Lord, the amendment is
that there is no existence of DPSC.
No.
Because you see this is simple. And forget about the amendment. If the board has taken over, that means, does it mean board has taken over means all the interview district-wise will go?
Well, the board says if the board has taken over, it should be done by the board. Well, kindly come to the amendment. Oh, yes, school could amend. Rules come and amend করে primary
2016 rules amendment triple one
বলছি I just kindly come to the amendment
page 111.
What is your interpretation of that?
Well, kindly takes up this.
Yes.
কমিটি করলো সিলেকশনের জন্য কিন্তু অ্যাপয়েন্টমেন্ট দেওয়ার কথা হলো ডিপিএসসি সেখানে ডিপিএসসি
কোথায় সেটা কোথায় Will kindly turn to the 2016 rules at page 111.
Page 111.
Yes.
Sorry, we took you back to that.
No. It's very important. I should have pointed out. I missed it. অ্যামেন্ডমেন্টটা করে কোথায় আনবো
এইটাই অ্যামেন্ডমেন্ট রুল
না
2016 রিক্রুটমেন্টের পরে 23শে সেপ্টেম্বর একটা অ্যামেন্ডমেন্ট হয়েছে দ্যাট ইজ দিস 23শে সেপ্টেম্বর
এইটাই সেই অ্যামেন্ডমেন্টটা দাও কোন পেজে আছে
না ওটা নেই ওটা আলাদা করে দিয়েছে ওটা রাতুলটা আলাদা করে
That amendment is of Rule 7.
রুল 7
Let's kindly come to rule 7 first. The board shall constitute selection committee within the jurisdiction of the council with the following members. The selection committee shall normally function for a period of 2 years. Now this 7 was amended. Now similar to what is the amendment sought for? The board shall constitute selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers in primary schools within the jurisdiction of the board. Therefore, the power of council was taken over by the board.
What is your interpretation? Then no counseling can be done by no committee can be constituted by respective council.
Cannot be. If the board takes over the entire selection responsibility, selection committee which was sought to be created under unamended section 7 now vanishes. And board says
The board shall constitute
Yes.
unamended portion. The board shall constitute selection committee.
Within jurisdiction of the council.
Just a moment. For the part, board will constitute selection committee for the purpose of selection and preparation of panel of such a appointed of teachers in person within the jurisdiction of the board.
Amendment one.
Yes.
The amendment says the instead of the councils now centrally. The board
Constitute the selection.
Yes.
But saying selection committee, there were separate selection committee for all separate districts.
Let me kindly read once again. The board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. Selection, preparation of panel is the duty of the board. In the affidavit, board say that the aptitude tests were done by district councils at the district quarter. I just place it once again. Therefore, this really goes against their own rules. Just once again, I place it. Note. Kindly come to 375. Paragraph 12.
সেকশন ক্যাটাগরি পিটি কাজের আগে যে ভিডিওটা দেখালে এখানে ওরা বলছে প্যানেলকে পাবলিশ করতে ওই কনফিডেন্স এটা ওই ভিডিওটা যেটা দিয়েছিলাম
দেখা হবে I say that paragraph 12 I say that 2016 recruitment process was a district-wise selection.
Their affidavit you are showing.
Yes, 375, paragraph 12.
Plan complexity. Obligations. বলা হচ্ছে কোম্পানি
বলতে পারবে
হ্যান্ডেড ওয়ার্ক করে
রাখো একটু দেখাই তারপর দেখাবে
Yes.
আর আপনি ডান থেকে তাকাচ্ছেনই না শুধু বাম দিকে তাকাচ্ছেন খুব বেশি কিছু আছে আপনার সংখ্যা
ওকে কিছু লাভ নেই উল্টো হতো না হতো তো I say that 2016 recruitment process was a district-wise selection based on the opted district of the applicant candidate.
Where is that board was that selection committee was done by the council?
What is that? I'm searching for that. This is the affidavit of the primary board. They say, I say that 2016 recruitment process was a district-wise selection, not centrally.
What was your reply to that? In the affidavit in reply?
But even if I did not reply, I accept this. I don't have to go file any reply to that. I say that 2016, kindly read with me.
That was not within the contemplation of these persons. Today, then suppose the hearing is taken up after 5 years. A person can argue that you should interpret my pleading as a deemed pleading construed to have included the challenge which I am arguing now.
Because what I am arguing is law. My lord, I am advancing before my lord the stand of a statutory authority.
They say that it was district-wide selection based on the opted district.
Kindly read.
Yes. District-wise. Your contention is that this should be construed to be meaning that the council, individual council constituted the interview boards.
No, I didn't say that. I am mistaken. The board has, by virtue of amendment of law, the selection is now conducted by the board. Now, the board in his affidavit says, the challenge was why not the aptitude test was taken. Then the answer board says, I say that 2016 recruitment process was a district-wise selection, not central selection. Based on the opted district of the applicant candidate, the interview vibavocy aptitude test was conducted at the centers under the respective district primary school councils and there is as such no distinctive record which is kept and maintained in such recruitment process. But if it is the central duty of a board to do it, they should have maintained the records. It is not left up to the districts. But when my lord is considering the public employment, maybe at the risk of repetition, lordship will kindly forget about the beneficiaries. My lord will be pleased to consider, my lord, the action of the statutory authorities. Because if the action of the statutory authority goes, my lord, the beneficiaries will not have no role to play.
ইন্টারভিউয়াররা বলছে এসসিতে কল পেয়েছে পেজ নাম্বার 518 ওরা ইন্টারভিউর 155 স্টেটমেন্টে ওরা বলেছিল সব ডিপিএসসিতে কল পেয়েছে
কোথায়
পেজ নাম্বার 518 পেজ নাম্বার 518
থার্ড ভলিউমটা But this affidavit of the board would be corroborated from, kindly turn to page 518.
Please come to your reply first. Your reply is at page 391, paragraph 11.
Yes, 391. It is the Uday affidavit. 391 lot is there.
It's 391, paragraph 11. Your
Yeah.
reply.
391. This is the opposition by board, not my reply. But this is detail.
You showed us page 375, paragraph 12.
Yes. This is the affidavit of board.
Yes. Now this reply to this.
No, this is not reply. That's another affidavit by board.
Yes. You have not given any reply.
No. I have placed before your lordship below the 3 consecutive affidavits by the board. I am relying on that. Let me, yes.
Page 403.
Kindly come to Milord. 403, yes.
28 April 2023. 28 April 2023 is second debit. First one was 24 January. Page 363 it starts. Now, file by the register affirmed.
No, my reply is at 403. May I place in detail? I did not place it because my reply does not really create any case. I have to depend on the affidavit of the state authorities. But still then, my lord is asking me, I am reading it.
This year doing affidavit, Mr. Bhattacharya.
But this
affirmed on 28th April.
Yes. This is dealing with Partha Karmakar's affidavit, the third affidavit of board.
403, my lord, the petitioner filed reply.
Yes, yes.
My
So
lord,
Partha Karmakar, third affidavit.
in opposition filed by the my lord, Dr. Partha Karmakar.
Ah.
My lord, your lordship kindly see page 400. Kindly see page 400. Affirmation the procedural portion.
That is the reply or to Partha Karmakar.
That is the date of affirmation, 20th day of April. But by mistakenly, my lord, 403, it is written 28th April. It should be, my lord, 28th.
20th April 2022. They are writing 23.
Wrongly, my lord, here is wrongly, my lord. They have done, my lord.
Affirmed on 28th of April 2023. Now kindly come to the reply. But a subparagraph A, on 7th of February 2023, the writ petition was taken up along with other 4 matters, and the Honorable Court was pleased to direct the board to come up with the breakup marks of last 10 panel candidates, district-wise, category-wise, medium-wise, caste-wise.
We only want to see what you said about that statement.
Which statement, Milord?
That district-wise, which you pointed out, paragraph at page 375.
Will kindly come to Milord. Paragraph 7. I deny and dispute the statements made in so and so. Admittedly, the petitioners did not ask for setting aside the recruitment of all candidates. It's the pair the petitioner to set aside the recruitment process, but after publication of list by the board, it is clear that law was not followed.
Paragraph 12, you have dealt with in paragraph 9.
Paragraph 9 Milord, deals with paragraph 7, 8, 9, 10, 11, 12. My Lord will kindly read the affidavit and reply all pleadings, Lord, in its entirety. Otherwise, Lordship would not be in a position to really reach to the truth, which is the role of the court. Kindly come to me, Lord. May I just read it? The petitioners did not speak about aptitude test in the writ petition, as they are sure about the fact that no aptitude test was ever taken up. After publication of the merit list, they came to know that marks were given in aptitude test, and accordingly, documents were filed to show that illegalities were committed in aptitude test, and that was never taken up. Recently, the Honorable Division Bench of this court passed one order directing the board to give 6 marks to all candidates. Is something else. Then kindly come to me, Lord, paragraph 9. The board is trying to confuse the Honorable Court. In 2016 recruitment process, no district-wise, category-wise, medium-wise, caste-wise data was published by the board. Untrained candidates were appointed, and strangely less meritorious candidates were selected by depriving the petitioners. The documents submitted by the petitioners during argument prove the facts. The board did not follow their own rules, and one absolute faulty merit list was published just to cover up the wrong done by them. The petitioners state that 2020 recruitment is not our headache. Then kindly come to me, paragraph 11.
Sir, contextual selection committee vote করবে কিন্তু সিভিল appointing authority is the DPSC rules.
Ultimate paragraph 40.
Yes, I've said faulty merit list.
Faulty merit list was not published.
But when we come to know that somebody below the merit ranking got appointment, then we say faulty merit list. My Lord will consider a candidate. He is not supposed to know all the facts in details. He comes before the court, makes an allegation that this is a public employment, therefore this merit jumping has been conducted. I have given a list, I shall give a list, which are part of the record. If one merit jumping would have caused for inquiry.
What list you have?
Yes. In person.
Relying upon supplementary evidence.
No, not supplementary. Lord, the merit jumping, Lord, list which has been mentioned in the can, which has been admitted by your Lordship. My Lord was pleased to allow, my Lord, some can to be admitted, and in other cases, let them argue if they want to argue. From that, my Lord, I have prepared a chart showing merit jumping.
Sir, এটা দিটা আপনার না আমি একদম এ দিয়ে দিয়েছি
Yes. I have just given the detail. Lordship will get details also. I have mentioned everything. এর মধ্যে মারামারি করো না, কোনটা কোনটা যাবে
স্যার এটা পাঠিয়েছি মেলে পাঠিয়েছি
আমি দিয়ে দাও হয়তো these lists have been handed over to the board.
আরে একটাই মেলে পাঠানো হয়েছে
List of merit jumping. This is part of can which has been admitted by your Lordship. I have given the detail.
Can 2 and 3. Can 2 and 3.
Mr. Bharadji, come to that letter. You have received our judgments. Kindly come back.
Yes.
Anything added, Mr. Dasgupta? Don't worry. If you both of you disturb him, it will be difficult for him to argue.
Oh, Judgment দেখাচ্ছিলাম
appointing authority
দেখাবো This is 2006 volume 6 SCC page 94.
94.
Come to paragraph 49 onwards.
পেজ নাম্বার 804 804 504 এবং ওটা না এটা এই বলি 804 8 বলে ক্লাস করতে ছোটটা এইটা লাস্ট ভলিউম ছোটটা
But that was a case between two financial authorities.
Serial number, which one?
Serial number 21.
20.
Volume 3.
Yes.
Now, that kindly 46, 47 deals with the facts little. I am not troubling my lord with that.
First.
Why it may be true.
First.
My lord got it.
Yes.
The relevant
হ্যাঁ বলছি যখন আমি টেস্ট করবো সব বলবো। Now kindly come to paragraph 44. In the absence of proper explanation, it was not open to the special court to make inferences or assumptions with regard to terms used in the documents. For example, SCB security ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio. Got it?
Para 44, Mr.
Yes. Give a little bit of factual background.
Yes.
Let me read once again. In the absence of proper explanation, it was not open to the special court to make inferences or assumptions with regard to terms used in the documents. For example, SCB's securities ledger in relation to the suit bonds, which pertains to the sale and purchase of the suit bonds with different counterparties. This document as such does not contain the description portfolio, but the said appellation has been given to it by the special court on its own. The special court has observed thereupon, therefore all such transactions were entered into by the bank on behalf of HPD. Therefore, they were transactions of HPD. This is amply illustrated by Exhibit 11. A portfolio represents stock held by SCB on behalf of HPD. HPD was entitled to enter into buy transactions and sell transactions in respect of securities coming under that portfolio. The portfolio was built up by SEB by purchasing securities at the instance of HPD. This is also called as building up a position. The suit contract comes under Exhibit 11. By the suit contract, the LOA come within portfolio of HPD. He was allowed to deal with LOA under the portfolio. We are afraid that this inference is not readily available expressly from the document, nor was there any other evidence given by any witness explaining the document suggesting it. Then Lordship may skip over, kindly come to 48. While it may be true that special court has been given a certain amount of latitude in the matter of procedure, it surely cannot fly away from the established legal principles while deciding the cases before it. As to what inference arises from a document is always a matter of evidence, unless the document is self-explanatory. We do not think that any of the documents placed on record during the trial were self-explanatory, nor were they explained by any competent witness on either side. In the absence of any such explanation, it was not open to special court to come up with his own explanation and decide the fate of the suit on the basis of his inference, based on such assumed explanations. In fact, these inferences run contrary to the oral evidence given by so-and-so. Then, Lordship, we kindly come to paragraph 40. Learned Counsel for CMF also contended the SCB failed to produce relevant documents that would have established what the 15% arrangement was. For this failure, he contended that an adverse inference should be drawn against SCB. For this proposition, he relies on judgments of this court in such and such. This argument is made by Learned Counsel for SCB. An adverse inference is a presumption which the court is entitled to draw under Section 114 of Evidence Act, read with illustration G thereto. Mr. Jethmalani contended that the weight of the authorities would show that unless there are some special circumstances making it obligatory for a party to produce evidence, no adverse inference can be drawn unless a party has been called upon to or ordered to produce the evidence and fails to do so. Mr. Jethmalani relies upon such and such. In Hiralal case, this court reiterated the observations of the Privy Council, where the Privy Council laid down the general rule of procedure that instead of relying on the abstract doctrine of onus of proof, a party to the suit, desiring to rely upon certain state of facts, ought not to withhold from the court the written evidence in his possession. In Gopal Krishnaji, the observation was reiterated and it was observed, even if the burden of proof does not lie on a party, the court may draw an adverse inference if he withholds important documents in his possession, which can throw light on the facts at issue. It is not, in our opinion, a sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession, which could throw light upon the issues in controversy and to rely upon abstract doctrine of onus of proof. In so-and-so was a situation of a fraudulent litigant basing his case on a falsehood and withholding vital documents. Merely relies on the observation made in Murugam and Gopal Krishna, both of which say that it is not a sound practice for those desiring to rely upon certain state of facts to withhold from the court the best evidence which is in their possession. On the other hand, the three authorities on which Mr. Jethmalani relied independently take the view that unless a party is called upon to produce evidence or ordered to do so by the court and fails to do so, no adverse inference can be drawn against such party. Mr. Jethmalani distinguished of the two apparently contradictory lines of authorities by pointing out that in the authorities relied on by Mr. Kapadia, the fact showed that there was a special obligation upon the party concerned to produce the relevant documents even without being called upon or ordered to do so, and that the party had failed to produce them. Further, he pointed out that observations of the Privy Council originating from Murugasam, which have been reiterated in the subsequent cases, including Citibank, would apply only if the party is desiring to rely upon a certain state of facts. He rightly contends that the 15% arrangement was neither any part of SCB's case, nor was SCB desiring to rely on the state of facts. In the circumstances, there was no obligation upon SCB to produce any documents to prove the case put forward by CMF. There was no situation in which adverse inference could be drawn against SCB. Finally, Mr. Jethmalani also asked that irrespective of what the parties did, The special court could have, if it was so minded, invoked its power under Section 165 of the Evidence Act and directed production of all documents it considered relevant, instead of relying on adverse inference which was doubtful in circumstances. This is particularly so with regard to the argument of CMF that the computer spreadsheets had not been produced as per para 7 of the written statement of CMF indicates. The CMF was aware of the existence of the such sheets and yet failed to call upon the SCB to produce it or seek an order for production of the code. The whole thrust of the impugned judgment is that the transactions between SCB and the counterparty banks, which were covered by the 15% arrangement, were sham transactions, making HPD the owner of the sued bonds. Where a transaction results in rights and obligations, it can never be treated as a sham transactions. Then, but I am not troubling with Lord Estoppel. Then kindly come to me, Lord. The relevant portion, paragraph 71. Mr. Jetmali rightly contended that when these admissions were placed on record formally, there was no objection by CMF to these admissions being taken on record, nor was there any challenge by CMF to the ruling given by the special court, overruling the framing of the aforesaid two issues. In the circumstances, he submits that it is not open to CMF to raise an objection at this stage. Apart therefrom, Mr. Jetmali also relied on Order 12, Rule 1 of the Civil Procedure Code to contend that it is open to a party at any time to give notice by his pleading or otherwise in writing that he admits the truth of the whole or any part of the case of any other party. This was precisely what happened during the trial. Merely because such a situation arises, the rest of the case does not get affected and has to be tried in accordance with law. In Bhagavati Prasad, while dealing with the argument that it would not be open to a party to sustain a claim on the ground which is entirely new or not pleaded, this court rejected the contention, held that it was a general doctrine which could not be applied irrespective of the facts of the case on hand, and observed thus. But I rely on this. Therefore, the pleadings, even it's not there, my lord, if it is appears from the proceedings before the court will definitely, my lord, look into this. Then para 74, with respect of that case, I am not telling, my lord. The point, therefore, my lord, which decides this court is that if something is there, some pleading is there, and parties want to rely upon, there is no problem in doing so. Finally, conclusion. Paragraph 97. Finally, it appears that there is not much to choose between the two contending banks, namely SCB and CMF. Both the banks have tarred by the same brush by Jankiram committee about fudging their accounts. However, it appears to us that the issue of ownership of the suit bonds could not have been decided on any basis other than what legal evidence showed. The situation is somewhat like a game of musical chairs. The one which is sitting on the chair when the music stops wins. Similarly, the situation before us. Once we eliminate the conjectural findings, we find that all the material evidence on record shows that SCB had purchased the suit bonds from NPCL by paying good money. The original LOA of purchasing suit bonds along with the transfer deed was handed over to SCB. As to how it went out of his possession, it appears to be subject matter of the FIR filed by the SCB so-and-so. It is pilfered or misappropriated by some officer in conspiracy with HPD, but that is a matter which will be tried by an appropriate criminal court. Turning to other side, claims, I am not placing that, that's not important. The consideration was that it is not always necessary that you have to plead everything positively, but it appears to court. Evidence letter?
Evidence to 2022 2022
Now, the latest view of the Supreme Court not on evidence is very important. This is 2022, volume 20, Hmm?
Page number 33.
Only like people on
Page 233. Para 70. Page 233 and my lord compare page number 855. বলেছি নিশ্চিত
This is paragraph 17 under the heading Purpose of the Evidence Act. You got it? Paragraph 17, 1-7. The purpose of the Evidence Act 1872 is to prove and disprove the existence of facts in issue and to find out the truth of the facts which are asserted by the parties, as the decision of the case lies upon and depends upon the truthfulness of those facts. The Act essentially does the balancing of interest between the parties to the proceedings, and such balancing has to be done by establishing the truth of the facts asserted. Ultimately, the Evidence Act is about the quest towards truthfulness. Procedure is the handmaid of justice and not its mistress. That is, procedure is not to control justice, but procedure is the helping hand of justice, and it helps to facilitate justice. It is well established dictum of the Evidence Act that misplacing the burden of proof vitiates the judgment. At the same time, the rule relating to the burden of proof is based upon certain practical considerations of convenience and reasonableness and also policy. But where there is a rebuttable presumption of law in favor of one party, the burden of rebutting it lies upon the latter. At the same time, when any fact is specially within the knowledge of a party, the burden of proving it lies upon that party. Not I am an individual fighting against the authorities, and authorities are in possession of all documents. The term especially means facts which are preeminently or exceptionally within the knowledge of a person. It is true that it cannot apply when the fact is such as to be capable of being known also by persons other than the party. This rule is an exception to the rule of burden of proof. Thus, when a person acts with some intention other than that which the character and circumstances of the act suggest, the burden of proving the intention is upon him. The bottom line of the purpose of the Evidence Act is to adopt a procedure that helps to facilitate justice. And ultimately, what is required is to unearth the truth to prevail. Now, this is the provision of law so far the Evidence Act and pleadings are concerned. Here, the sufficient pleadings are there to show that there has been huge irregularities and scam so far the selection of 2016 is concerned. Now, I have had referred in my pleading that there has been a CBI inquiry. I would place before your lordship the record, the charge sheet filed by the CBI, which the court cannot be shut, not to look into it.
No date.
Charge sheet filed by CBI in jurisdictional court.
Connection with
in connection with 2016 selection, this selection which is now being considered by your lordship, and
page number 30. Page number 30. Charge sheet. Charge sheet. Charge sheet. Part
of candidate can see. Not only that, there is procedure. The ability to hear stocks and document, not the way.
Now they want to shut the court. Yes, you are shutting the court. Let us go through it.
That can 22/5.
In my petition, I have said no question of affidavit.
When was it done?
Recently filed. Recently, 2-3 days back. This is 2-3 days back. Investigation started then. Now, that court, I again will say the constitutional court cannot be put to a closure of not looking the relevant documents when the allegation is of scam.
Copy to your other side and hearing on the next day.
Next.
And other points you got.
No, therefore, no, other side is next. Kalke shunben it, pore din. No.
Mr. Majumdar, it is a charge sheet which has been filed. It is not a document out from the pocket of the very person. So he will not advance his arguments today on that.
Next.
We are giving you a copy. We have not formally said it.
তোমার দায়িত্ব যে আমি এই যে করি না
তুমি যে জাজমেন্টের লিস্ট তৈরি করে তাপসদাকে পাঠিয়েছি ওটা পাঠিয়ে একদম টাইপ করা কপি সেটা
This is 2016 recruitment process.
স্যারের প্রিন্ট No recruitment. No recruitment.
Nabilad, why are they scared of looking at the documents?
This charge sheet is pertaining to which
2016 date, primary recruitment. 2016 primary recruitment. The all authorities are under custody.
That all the copy, then you advance your argument.
No problem. Supply, but they have the copy because they are in the group of the accused.
একটা কপি দিয়ে এখন দেবো না
একটা সফট কপি প্রত্যেককে পাঠিয়ে আরে পাঠিয়ে দিও এখন শুনছেন জাজমেন্টের লিস্টে কোথায় আমার কপিটা কোথায় আরে এখানে জাজমেন্টের কপি নেই তোমার আলাদা করে
This is a document which is what is the big hue and cry. We are not shutting you out. Let us see because
তোমাদের
We are at the production of the document.
তোমাদের নিয়ে না কাজ করা হচ্ছে ইম্পসিবল
Whatever you say, I shall hear, but it is a charge sheet. If it is not pertaining to date 2014, date 2014, then question is not arise.
He could have got many other documents, we were restricted by the law.
Mr. Laidi, we have heard all of you extensively. We cannot shut him down. Let him complete his arguments. Allow us to proceed.
Does not have any reference to this.
Mr. Banerjee, Mr. Majumdar, you're getting an opportunity to come and tell us that.
Yes. Now, Lord, I now take it, Lordship, the corruption, the Supreme Court says. তোমার তো আছে বাবা তোমার লোকের তো জেলে আছে ওটা কি এখন দিচ্ছ কেন সফট কপি পাঠিয়ে দিও এত হাত দেওয়া যাবে
এটা সার্টিফাইড কপিও তো নয় স্যার আপনি
তোকে সফট করে দিয়ে দেবে বাড়ি থেকে পড়ে এসো যাতে তোমাকে জেনে যেতে তাহলে I am not the Supreme Court, not what the Supreme Court says on corruption.
Give them one hard copy, they shall share it.
Yes, if you share it, you get it.
And you send this copy to all of them.
দিয়ে দাও
Just now today.
চার্জেস কপি বাদ দিয়ে অন্য কপি থাকলে দাও, না থাকলে পরে দিয়ে দিও।
Yes,
তাহলে পরে দিয়ে দিচ্ছি।
আমি সব কপি তোমাকে এক্ষুনি আর ড্রপ করতে হবে।
হার্ড কপি দাও একটা আগে।
Yes.
Now will kindly come to below 2013 3 SCC, page 1. আমার বই কোথায়? 2013 3 SCC.
Can we suggest one thing? So far as the judgments which you are referring to, tell us which judgments. We will go through the judgments and we will go ahead.
Lord, I have the,
But short,
yes,
for your advantage also.
my lord. Lord, I have given the details, my lord, in the compilation.
There are
In,
how many judgments we will read. If you
Lord, at least, my lord, 10, 12 judgments I have to cite.
just tell us those judgments, we shall read.
If your lordship permits me to cite the recent division the judgment of this court, which was upheld by the Supreme Court in SSC, I think that covers all these judgments.
That has been given to us.
Yes, Lord, we can, Lord, place that, the Lord should find all these judgments, Lord.
Entirely do not place. That is a 400-page judgment. It will not be used.
The principles, I will just, Lord, say the principles.
So, what is you give us the citations which upon which you will be placing the.
Yes, Lord, kindly, charter diyechen.
There are 3 compilations. Which, the 3 volumes. Have mercy on us.
Total 23 judgments in 3 volumes, and the index is there. In first volume, index is there. Kindly take the first volume. That is index. So index.
দিলাম লিস্ট করে আমি জানি না তোমরা কাজের সময় কেউ থাকো না।
Where are the paragraph numbers?
এতে কিছুই নেই।
But we don't have the references. At least let us have a copy. The copy দাও কিছু তো জানি না কি দেখা।
No, but I just indicate not what I'll rely upon.
You have already relied upon 2022 volume 20 SCC.
Yes.
And 2006 volume 6 SCC 94.
Now, that I shall immediately place 2013 3 SCC page 1.
2013.
3 SCC, item 3 of the.
Which paragraphs? 92, 93, 95.
Yes. No, but I have to check it not while placing.
That is given in compilation. Serial number 3.
Yes, kindly turn to blood. Yes, kindly, my lord, this is very important, my lord. So for the role of
2013 volume 3 SCC 1.
Page 1. The corruption and the role of the court and authorities.
You are placing para 90.
Para 92. At page, this is page 218 of the compilation. Compilation কোন volume দিয়েছে আবার? Index করে দাও যথাযথ।
Same index first volume page 2 same index এখানে 176 ওটা শুরু হচ্ছে paragraph 92 টা 218
This is unfair. তোমাকে বারবার লিস্ট করে দিলাম তো সেই লিস্ট তুমি কেন দিলাম? This is
জিজ্ঞেস করুন কি বললো যে আমি চলুক
তুমি হাতে রাখবে।
Request you summarize your argument what you have submitted before us and give us the judgments which we will take it from Mr. Ram.
I shall indicate. Mr. For those who have not been in a position to do that, I shall.
Summarize your argument.
My argument is very short.
Yes.
That the selection process initiated by a public body has to be above board beyond question. Any infraction would vitiate everything. Otherwise, people will lose confidence in the entire system. And corruption would become a part of machinery which will destroy the democratic process.
Yes.
The court's outlook with regard to the public employments, if it is, even in one or two cases, if it is found that it was in violation of statute, Supreme Court, even after a continuance of 20 years, said, no, you go. Many judgments went up from our court also. I shall refer those judgments. There is no scope for any compassion or sympathy for illegal recruitment. But this is the basic thing. Now, before I conclude today, it's over. I just will not rely this judgment, where you're placing below the paragraph 92, then conclude today. Corruption in a civilized society, 92, Biranopoi.
At page 218.
218.
Yes.
But before I start this admitted position, the court have to take judicial notice of the fact that there has been criminal investigation related to this recruitment, and in prima facie, the persons have been taken into custody and charge sheet have been filed, which proves the corruption. And that's the criminal part of it. When it comes to the question of constitutional court's intervention, then we'll have the basic principle of Article 1416.
So what is the date 2014 was included within that, or it was pertaining
2016 recruitment.
2016 recruitment?
That's a date and 2016 to include.
No, but I would stand correct after placing.
Pertaining is 26 September 2016 advertisement.
Right. And the corruption in a civilized society is a disease like cancer, which if not detected in time is sure to spread its malignance among the polity of the country, leading to disastrous consequences. Therefore, it is often described as royal thievery. Corruption is opposed to democracy and social order, as being not only anti-people, but also due to the fact that it affects the economy of a country and destroys its cultural heritage. It poses a threat to the concept of constitutional governance, which pricks me more, and shakes the very foundation of democracy and the rule of law. It threatens the security of the societies, undermining ethical values and justice, jeopardizing sustainable development. Corruption devalues human rights, chokes development, and corrodes the moral fabric of the society. It causes considerable damage to national economy, national interest, and the image of the country. Now, the basic index of human development is education and health. But if the education is vitiated with any sort of corrupt practice, it really chokes the development of ethical values and sense of justice. আজকে না সবই আজকে হবে নাকি Now, may I stop it today? Deeply. Next time, I shall just take the other judgments and conclude.
Because your who is appearing for the so what is it for
Appearance given.
yes, please.
আমাদের সবাই দিতে
এইটা আমার মার্ক করে তোমার কাছে রাখো, দুটো তোমার কাছে রাখো, উপরে লিখে রাখো বিআরবি বলে। This is the list that I would basically Lordship may take into consideration not, but this is the chart of rank jumping, which will appear from the pleadings.
given to the board.
Because we don't
Yes, but their opposition doesn't matter to me. It has to be opposed by the board.
Yeah, nobody. ওরা চিৎকার করছে, ওরা ইচ্ছা করে।
Well, there are cans for the TET who didn't pass the TET also.
আমাদের কেউ নেই। Nowhere in our
যদি ওপেন করতে হয়, সব ওপেন হয়ে যায়।
সব ওপেন করে দেয়। হ্যাঁ।
up on the next date, we also can come up with
I shall just hand it over chart.
three volumes have been given to
The judgments.
you can only
I just indicate below the cases.
only you be facing all the
No, may not be. May not be.
if possible, Mr. What is it to point out?
Here and now. Here and now I shall do it. Here and now. देखिए list कोथा है? এটা প্রেস করেছি।
So Wednesday, we are reopening on 27th, 24th. There are intervening 25, 29th at 2 p.m. we are keeping. Yes. No, Mr. shall get
কম্পাইলেশনটা কি মার্ক করি এটা সেম না না এইগুলো ঠিক আপনি বলে দেন স্যার এন্ট্রি নাম্বার
space. Please keep it with you because 44 files are there. Keep it with you and remind us when you will be here. If he contacts them, after that we can. Yes,
I will just indicate me lot. May I just indicate in your? ঠিক মেরে দেয় বলো।
1 থেকে 4, 6 থেকে 10 আর শেষের ওই সরুটা হ্যাঁ সরু প্রথম পেজটা
খুব এটা কিন্তু কোর্টের ব্রিফ সেভাবে
সরুগুলো
only one
এই কটা ঠিক মারো।
have considered that small volume.
এটা এক না না এখানে অন্য জাজমেন্ট আছে
You have already given us 2006.
2, 3, 4, 6, 8, 9, 10
বললেই তো আমরা চুকে নি বিকাশ দা
11 ব্যাস।
ও বিকাশ দা বলুন না আমরা লিখে নি।
হ্যাঁ ও বলে দিচ্ছে তোকে দাঁড়া।
স্যার এটা সেকেন্ড জাজেস করে
Reading that number 2 from which this compilation?
Yes, well, I'm reading that from the compilation of your lordship, which was handed out to your lordship, volume 1. আর এগুলো দরকার না
এটা তারা 21 ইমপ্লয়েড প্লিডিং
ও এটা দেখানো হয়ে গেছে 22
আর 22
ব্যাস
আর এটা সেকেন্ড যে
একই জিনিস তো টিক মেরে দাও
এটা বলে
তাহলে দেখে দেখে টিপ মারো
হ্যাঁ স্যার ঠিক আছে
দুটো তো মিলে
ওকে ঠিক আছে
এটা সেকেন্ড জাজের কপি
সেকেন্ড যে এই দেখো ছবি তো
Yes, that
তিন,
will be.
4
ছয়
6 8
হুম।
একজনকেও ছবি তুলে নিজেদের এতে নিয়ে টিক মারা গুলো লাগিয়ে এতে কোনো টিক মারিস না এগুলো সব অ্যাপগুলো দিয়েছিস
এইটাই তো বোঝ হয় এই তো কটা আছে এখানে 12 এইটাই তো ব্যাস আর এইটা 2006
পরের পেজে আবার দাগ দিচ্ছেন নাকি?
দুটো ওই যে ইমপ্লয়েড ক্লিয়ারিং যেটা অলরেডি রেফার করে দিই
এটা ইন্টেলেকচুয়াল প্রপার্টি রাইট বুঝছিস দিয়ে দাও
কোনটা কোনটা পরের পেজে গুলো দাগ নাই
না 21 আর 22 যেটা দেখা
We are declaring the cycles.
এটা কার
এটা আপনার কপি আপনার
এটা তোমার কাছে কমেডি
You have tick marked all the judgments.
no out of 23 only entry number
10,
2 3 4 6 8
Joseph
9
is-
10 11
three judgments already been cited
and 21 and 22 11 একই আছে এটা পরে পেজে একবার
আমি told both the juniors of Mr. Bhattacharya citing different judgments. So it compile
no
right hand side one.
no
I should take it down. 2012 volume 3 SCC.
দেখ
2012 volume 3 SCC 619. 2013 volume 3 SCC. It has already been cited. 20 volume 3 SCC 888. 2012 volume 5 SCC 370.
2012 volume
5 SCC 370. 2021 volume 16 SCC 217. 94 volume 4 SCC 164. 2025 SCC online Supreme Court 719.
this court judge
This court judge. 2022 volume 7 SCC 482.
implied
22 volume 7 SCC 482. 2006 volume 694 already you have
cited
taken. And 22 volume 20 SCC 2333
Also
that's
in-
also judged.
second one chairman কোর্টকে বলো, কোর্টকে
এটা আমাকে দিয়ে আমি মার্ক করে রাখবো। আমাকে সেকেন্ড থার্ড
তুমি বলো না, তা না কোর্টের মধ্যে
ফ্যাক্টসের দরকার নেই।
স্যার কি বলছেন বলুন না সামনে।
বললাম তো নিজেরা কি ক্লেম করে আমি আজ পর্যন্ত বুঝিনি, ওরা ব্রাহ্মণ ক্লেম করে।
ওই একদম শিক্ষিত ব্রাহ্মণ।
উনি কি ক্লেম করে আমি নিজে বুঝি না।
প্রকৃত মানে অফিসিয়াল পোস্টে বড় বুদ্ধি।
Bari, let please intimate Mr. Bari that we are keeping both those matters on. Or it will appear.
এই স্যারের কাজ করতে
লোকেরা বম্বে থেকে ঘুরে এসছে।
In my matter, the issue is that with regard to the realization of the yes, we know that, yes.
বলা হয়ে গেল
Take it up on 4th November, but be here. The other side.
বম্বে থেকে ফিরে এসছে।
বলছেন
Copy has been written.
জড়িয়ে যাচ্ছে।
এবার না ও না ঠিক আছে না। আরে পার্থ চ্যাটার্জির বেল অ্যাপ্লিকেশনটা ওখানে সার্থকে গেলেই পাবে। সার্থকে যাও, সার্থকে আপলোড হয় পার্থ চ্যাটার্জির বেল।
আরে এটা তো অভ্রই পেয়ে যাবে সার্থক থেকে। চলো এই কার বই, বই নিয়ে নাও, বই নিয়ে নাও।